Good morning, everyone. I hope everyone's doing fine. And we're ready for day 2 of this hearing. Mr. Fraser, you ready as well? Yes, I can see that. For the record, can you confirm to us that you're Alexander Fraser? You should switch on your microphone and then leave it on so you don't have to think about it.
Okay.
Good. You're CFO of Discovery Global.
That's correct.
You've provided us with 2 written statements. The first one was dated 30th of September 2022, the second one 18th of September 2023. Is
That's
that
correct.
right? You have your witness statements with you there in unannotated copies. Excellent. You're heard as a witness in this arbitration, as you know, and you're under duty to tell us the truth. Can you please confirm this by reading the witness declaration into the record?
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you. So now you know you will be asked a few introductory questions by claimants, and then we'll turn to respondents.
Thank you,
Mr.
Madam.
Cushingham.
Yes. Mr. Fraser, do you have any corrections to make to either of your witness statements?
I do not.
Thank you. I will now turn the floor to Mr. Alexander.
Thank you, Madam President. Mr. Fraser, it's a pleasure to meet you, sir. My name is David Alexander, and I'll be asking you questions today. Could you tell me first, where are you employed today?
Where am I employed today?
Yes.
I am no longer employed by Discovery Global. I'm doing other things outside the oil and gas sector.
Are you,
I've actually now run a farm down in the West Country, which I inherited a while ago.
when did you last practice law?
1993.
And at the time, were you barred in the United Kingdom?
I was I qualified I was admitted to the English bar and then qualified as a solicitor.
Thank you. When was the last time you spoke to Mr. Crow, either in person or by phone?
Probably in the in the last couple of weeks, I would say.
And prior to that, when was the last time you'd spoken to him?
We've had a few conversations over the last couple of years.
And when was the last time Mr. Lewis spoke to Mr. Crow, if you know?
I don't know the answer to that question.
Do you know if he's had any contact with him in the last 6 months?
I know they're working on another project in America today.
And is that in the oil and gas industry?
It is, yeah.
And they're working together in business on that?
To the best of my knowledge.
When you went into the Slovakia project, did you have any prior experience on oil and gas regulatory matters in Slovakia?
Not on, I didn't have experience on regulatory matters on oil and gas in Slovakia. I'd seen similar processes in Poland. Right.
So when you went on board with Mr. Lewis, I understand it was originally as a part-time basis. Is that on a part-time basis?
That's correct. While I was exiting my previous company, I was on a part-time basis with Discovery, and then it became full-time as my previous job concluded.
And when did you assume the title as Chief Financial Officer?
I would say I was acting or temporary Chief Financial Officer in late 2014, informal, if you like, and it became a formal position in first quarter, I would say March 2015.
And could you tell us generally what your duties were as Chief Financial Officer?
My duties were to supervise the fundraising activities, working with Mike Lewis, and also to look after to run the accounting for the joint venture in Poland, sorry, in Slovakia. We also had operations in Poland at that time, which were winding down. And that's about it.
Did you have any responsibility for monitoring regulatory or legal matters?
Not at that stage, I did not know.
Did you assume those responsibilities later?
Once I became full-time, I started to take over the responsibility for, I would say, for the higher legal matters in Bratislava initially, and the permitting side in the eastern part of the country was looked after more by the team there. Right.
So your duties in that regard would have been assumed roughly in July 2015.
Yeah.
When you came into that role, supervising matters in Bratislava, legal matters, did you have an opportunity to review the due diligence work that had preceded the original investment back in March of 2014?
I had an opportunity to look through it. The deal had been done by that stage, so there wasn't much I could, there wasn't. I probably had a quick look at it, but I didn't spend a lot of time looking at it. Did
you see materials concerning the overall regulatory environment of Slovakia?
Could you be a bit more precise, please, on what you mean by regulatory environment?
For example, the Geology Act.
I understood specific areas of the Geology Act, what was involved in licensing, for example.
Do you recall seeing at that time the material that was projected yesterday on the AOG slides concerning Article 29, paren 3? Does that ring any bells?
I became aware of Article 29.3 in, I would say, probably mid or late 2015.
Mm-hmm. And just so we're clear on that, Article 29.3 is the provision requiring, in fact, maybe to be fair, we ought to put it up on the screen. Could I ask you to pull up R42, please? And if we could scroll to Article 29. And paren 3. There we are. Thank you. Let me know when you had a chance to take a look.
Okay.
You may have heard this referred to as the permission and notice provision.
I haven't. No.
You haven't. All right. So in mid 2015, shortly after you came on board, your testimony is you did become aware of this. 29.3.
Let me clarify that. I wasn't aware of that specific provision. I was aware of Article 29 being a route to acquire compulsory access, but that particular subparagraph I was not aware of.
And that, of course, you're referring to 29.4, the following provision,
Mhm, mhm.
right? Do you recall when you first became aware of 29.3, the permission and notice provision?
I don't recall when then.
But you're confident you have seen it sometime in 2015?
I can't say that I saw that particular one in 2015. As I say, the day-to-day permitting was handled by other members of the team, including our Czech country manager, who was very experienced, and he was very much our go-to person for all things permitting, very conscientious, and he held our hand to make sure that we complied with all aspects of the permitting side, including Article 29.3.
And could you identify that person by name, please?
Stanislav Bernarda.
And was he Slovak?
He's Czech.
Had he had prior experience in the Slovak regulatory environment? Do you know?
He did. He had been, he's got 30 years experience in the Czechoslovak oil and gas sector. He's spent 20 years working for MND, which is a large Czech oil and gas company. And he was country manager for Alpine Oil and Gas since 2006.
Before entering sites that were identified for exploration activities, were you aware that there was a requirement under Slovak law to obtain permission of landowner and give them notice?
Well, we couldn't enter a site until we had an agreement with the landowner to acquire a lease of the site.
And what about access to sites?
We would also be, I mean, access is just as important as the location itself. So we would do the same investigations on how to get to the location as to ensuring that we have the rights to operate on the location.
And did you participate in the investigation of the Smilno site, as you say, on the just as important issue of access?
I did not. No, that was handled by the local guys, which was Stanislav, Ron Crow, and some of our Polish team, Maciej Karabin and Maciej Karabin.
Now, if I could ask you to turn to your witness statement for a moment at paragraph 35, and I'm going to be asking you about at the top of page 13. Now, you are referring here, are you not, to access to the Smilno drilling site, correct?
Correct.
And you testified there, it was our understanding, and let me just pause there. When you refer to our understanding, who is that?
The company, I would say. So that's Mike Lewis, Ron Crow, me, Stanislav, and others.
And the persons you've just mentioned, they were really the top leadership of the company, correct?
Yeah.
Now, did you have the understanding yourself that the road was a public road and that no permission was required from any person to use the road? Was that your understanding?
That was our understanding. That's correct.
Not quite my question. Was that your understanding?
That was my understanding.
And tell me, sir, how you came to that understanding.
There were internal reports and also updates, which form the basis of updates circulated to the JV partners, which included an update on matters like securing the location, permitting, access to the location and other matters such as dealings with contractors. And those reports discussed the progress that was being made on securing the location at Smilno and also the access road.
Do you remember reading a report that said specifically that no permission was required from any person?
Yes, I do, yeah.
And do you know if that report is in this record?
I don't know offhand.
Did you have any discussions with Mr. Benata about his availability to testify in these proceedings?
Yes, I did.
And he was not available?
We asked if he would be willing to testify, and he said that he was not willing. He had found the whole process too painful.
Well, I'll try to make sure today I don't give you the same experience, sir. And do you recall the explanation for what you assert was a report that said no permission was required?
The explanation was that the road was a public road, was publicly accessible. And there had been conversations with the mayor and also with the farm, which farmed all the land round about. They would have been the main user of the road, but the mayor told us that the road was publicly accessible.
All right. Now, if possible, Mr. Fraser, I'd like to ask you, when you are identifying us or we, that you be as precise as possible, because as you know that, and this is no criticism, but your witness statement often says we, and of course we have no idea who that is. So could I ask you to answer that question again with specifically who the persons are that were involved?
Sorry, could you repeat the question then?
And there had been conversations with the mayor and also with the farm. Did you have any conversations with the mayor?
I did not. Ron Crow did, Maciej did, and Stanislav Benada did.
Did you read reports of their conversation with the mayor?
I read a internal report that said that they had met with the mayor in June or July of 2015.
All three of them?
Yeah.
And did you have any conversation with Mr. Crow about his availability to testify?
I did not, no,
Do you know if Mr. Lewis did?
I don't know.
All right, and you mentioned another gentleman. Mr. Is it Carabin?
Caribbean, yeah,
Did you have any conversations with him about his availability to testify?
I did not,
Do you know if Mr. Lewis did?
I don't know.
So what do you recall that the internal report to which you referred said?
The internal report said that there had been a meeting in Smilno with the mayor, between the mayor, Stanislav Benada, Maciej Carabin, and a representative of the farm. And they had discussed the use of the road. And subsequently, Ron reported to the company on.
That's Mr. Crow.
Mr. Crow, sorry. Reported that the road was publicly accessible as a result of that.
Did he say anything more about the reasoning provided by the mayor?
No, he did not. We were told simply that the.
Excuse me, that's an answer to my question. You don't need to go on beyond just answering the question, if that's all right. And would it be fair to say that there was no discussion in the internal report to which you referred? Well, let's back up. There was discussion about historical use of what you've referred to as the road.
That's correct. There was discussion about historical use, yeah.
And it had been,
Pardon me for interrupting. I don't like doing this. You asked the witness a few minutes ago whether he remembers reading a report. He said yes. You asked him if he knows whether the report is in the record. He said he did not know. Do you know whether that?
I
report's
don't
in the
know
record?
what report he's referring to.
Very good. Thank you.
And while we're at interrupting, at what time does this conversation of your three colleagues take place?
In June 2015.
15.
Yep. June or July. And it will have been reported, I'm pretty sure it was reported to the joint venture partners in a follow-up report to partners.
Am I not mistaken that in May 2016, your lawyer writes to the mayor specifically asking the same question?
Asking this, he asked for a declaration, if you like, that the road was publicly accessible at that point, a declaration that he could show to people. But we were told in 2015 that the road was publicly accessible.
Thank you. Apologies.
Thank you, Madam President. That actually is a helpful segue to what I wanted to ask you. Prior, you remember, of course, the May communication. We'll get to it in a moment, but you understand what Madam President is asking about. That was a letter by Mr. Sikora to the mayor. Is that correct?
That's correct.
All right. And other than the internal report to which you've referred and the May letter, are you aware of any other documents that were considered before AOG entered the site on the issue of access, road access?
I'm aware that there were several meetings with the mayor during 2015 when this particular location was discussed. I believe, I'm not sure whether he suggested we look somewhere in that part of that area around the farm around adjacent to Smilno, or it's possible we said this is where we would like to go.
Excuse me, Mr. Fraser, is this a conversation you had with the mayor?
I'm saying what I was aware of. I didn't have the conversation, but I was aware of that. I'm aware that there are a number of conversations with the mayor.
Right. And these conversations you're describing now, were they reported to you in any written form?
They were. There were updates. I mean, 2 or 3, I don't recall, during 2015, during that time from May to September, say, when we were told about conversations with the mayor about going to drill at Smilno.
Let me ask you, if you would, if I could ask that R155 be put up. Can you see that all right, Mr. Fraser?
Yeah.
All right. I noticed that at the very top of the page, your name appears, but it appears to be an email from Mr. Sikora, who I understand to be an attorney. Is that correct?
That's correct.
He was representing AOG.
Mm-hmm.
And that is the email address of the mayor, I take it, Smilno 2001.
I assume.
Do you know why your name appears at the top of that?
I don't know. It's possible that he sent me the email as an attachment, and then when I opened it and printed it off, it came up like that. I don't know.
I sort of assumed the same thing, but hard to know. A little unusual in presentation. So let's back up for a second before we get into the letter. Prior to this time, prior to May, are you aware of any documents in the record that refer specifically to the statutory phrase public special purpose road?
I'm not aware of any documents in the record, no.
And were you familiar with that phrase prior to 17 May? Public special purpose road.
I became aware of that phrase, I would say, during that spring of 2016, sometime early 16.
But prior to the spring of 2016, you had never been aware of the statutory phrase, public special purpose road.
That's correct. We just thought the road was publicly accessible.
Right. And so let's go then back in time to December 15, before you entered the site. At that time, the only discussion you'd had was whether the road was public, but there had been no discussion about whether it was a public special purpose road, correct?
I wasn't party to any discussions like that. I'm not aware that anyone else was.
You don't recall any reports or memoranda of any sort referring to the issue of public special purpose road?
That's correct. We simply understood it was publicly accessible.
And you came to learn that there was a specific statutory provision, as you've just noted. How did you learn that? Public special purpose road?
I believe that I would have had that explained to me by Mate Sikora.
Now, what firm was Mate Sikora with?
He had his own firm of lawyers called Sikora and Associates
By whom was he engaged?
by Alpine.
And what was his instruction? What was he asked to provide counsel on?
He,
Apologies. The question was, and what was his instruction? What was he asked to provide counsel on? And that would be protected by legal privilege. And so we would object to this line of questioning.
Yes, the witness, you can say whether you want to answer this question or not. The tribunal has no problem with your answering it.
Madam President, if I may, I was not intending to ask for the actual communications, but I was only inquiring as to the nature of the engagement.
Yes, but depending on what the nature of the engagement is, it may cover the actual questions asked, and they may be privileged. So why don't you try to answer why did you retain Mr. Sikora in general terms?
we retained Mr. Sikora because he was the lawyer we've been working with until then, who we continue to work with, was Pavel Vargastok, whose English was not as good. So Mate had a good profile. He was active in the region. He seemed to have good experience. And so we engaged him to work alongside Pavel Vargastok.
When did you retain him?
Who Mate Sikora?
Yes,
I would say in April, possibly. About
2016,
yeah.
yes.
March, April, I don't recall now, but probably March. Yeah.
Madam President, I'm sorry, what did you have?
No, I was wondering where his office is, but I see it's not in Bratislava. So it is in the region where Smilno is located.
Correct.
Attention, please. The fire alarm is about to be tested. Please take no action.
Stop asking questions.
Ladies and gentlemen, may I have your attention, please? Due to circumstances beyond our control, it has become necessary to evacuate the building. Please leave the building immediately by the nearest exit. Do not use the lifts.
So we were instructed not to evacuate, right?
Attention, please. Attention, please. The fire alarm test is now complete. Please respond to all future fire alarms.
Do we still take no action?
I think we're allowed to take action again. Good, so please take action.
Thank you, Madam President. So to return, Mr. Fraser, you had earlier said that local matters involving permitting were handled by Mr. Bonata, even legal matters, is that correct?
I would say Mr. Bernardo together with Mr. Crow and Roger Carabin.
And in this particular situation where Mr. Sikora was involved, you were copied, you assume, by reason of the presence of your name on the email. You had become involved in that particular work. Is that correct?
That's correct. I mean, once the road was blocked in January, I started to take a more active interest in this issue. And I was struggling to be able to work satisfactorily with Pavel Vagastok because of the language issue. And I was recommended Mate Sikora by somebody, so we brought him on board as well.
Now, Mr. Fraser, I don't have the pleasure of knowing Mr. Sikora, but I was struck in reading this note by the particular language that was used. Well, first, the simple point, as a follow-up to our phone call, were you on a phone call between Mr. Sikora and the mayor?
No, I was not.
And you did not see any note of that phone call other than this email. Is that fair?
That's fair, yeah.
So as I read this, I found myself sort of curious about the language used. I would like to ask you for information on the nature of the road specified in the attachment to this email. Now, the attachment, I gather, was some sort of land record, is that right? If you know.
I don't know what the attachment was. It looks like it's a Word document.
Do you remember what the attachment was?
It's possible that it was some advice from him to me on the status of the road.
Which would have been shared with the mayor. Is that correct?
That's what it looks like. That's correct.
All right. Now, without first speaking to the president, I'm not going to ask you this question, but Madam President, I would like to inquire about that and request that it be produced because it's obviously been disclosed outside of the privilege.
You want to ask questions or you want to ask for production?
I would first like to have production, and then I would like to ask some questions, but I could perhaps ask a few preliminary questions about it even before I have, if the tribunal would be so inclined.
Yes, maybe you do so, and then of course we will give the floor to your opponents to see what
Of
they
course.
think about it.
Thank you
Yes.
very much.
Can we just take a moment to confer amongst ourselves I just want to ask a
Can we
question.
Can we hear the preliminary questions or
Um,
not?
Well,
There's no application pending at the moment.
I have no objection then to him asking preliminary questions.
You can
but-
still then, if needed, object to a specific question,
Yes,
right?
yes.
Try to think how to do this carefully. Well, I guess just for purposes of really the record here, to give you a fair sense of what I would inquire about, I'll ask them and understand that you obviously then may, you will have a role to perform, I understand that. Mr. Fraser, I infer from your testimony and the subject matter of this letter that the content of the attachment concerned Mr. Sikora's analysis of the public special purpose road question. Is that correct?
I would think that's correct, yeah.
So the material was provided, and do you recall that it included a analysis of the statute?
I don't recall, no.
But you are quite sure that this was the first time frame that you had heard this phrase, public special purpose road, the statutory phrase?
I would say I first got involved with the road issues in January, February of 16. We engaged Mate Sikora shortly afterwards. And at some point between the beginning of his engagement and this date, I don't recall when exactly, he would have explained to me about public special purpose road. He discussed it.
Now, the language that I mentioned before that I was intrigued by suggests that this is a new conversation between Mr. Sikora and the mayor. Would you agree with me? Let me be a little more precise. There's no suggestion in his introduction that they had been, other than the phone call, there's no suggestion that this had been a topic on the table for a significant period of time. Would you agree?
Are you talking about between Mr. Sikora and the mayor?
Yes.
I can't comment on that.
So then he proceeds to say, we would like to express our opinion that the road in question is a public special purpose road. You see that?
Mm-hmm.
And that was outlined in more detail in the attached memorandum, as you recall.
I'm honest, I don't recall I don't recall the content of the memorandum, but I expect it would have just covered questions like that.
Do you recall how long the memorandum was?
I don't know. I'd say I'm guessing a page or two.
Now, in response, if we could turn to Exhibit 15R156.
Before you do, may I ask one quick
Of course.
question? Just to pin this down, so there's no misunderstanding on the record. In response to Mr. Alexander's first question about the attachment a few minutes ago, he asked, do you remember what the attachment was? And your answer was, it's possible. It was some advice from him to me on the status of the road. Do you remember whether that's what the attachment was?
I don't remember. I'm just going on what the attachment says, what it says in the attachment there. Oh, sorry, do I recall what the question, what the advice was?
No. Do you recall whether or not, I suppose is the question, the attachment to this email 155 was advice from Mr. Sikora to you writ large?
I don't recall. I'm just going on how the document is described there. It's possible that it was a memorandum in Slovak, because he would have communicated with the mayor in Slovak, but I honestly don't recall.
I understood you before to say, yes, it was an analysis of his Sikora's understanding of the concept of public special purpose road, or it was that not an assertion, but more maybe?
Correct, more of a maybe. I don't recall the attachment. I don't recall the contents of the attachment, but looking at the title there, that's what it looks like it was.
May I ask one or two further questions, again, just to be certain? Do you recall receiving, you or the company receiving advice from Mr. Sikora on the nature of the road.
Yes, we did.
Do you recall whether that advice was the attachment to this email?
I don't recall that, no.
All right, thank you. Excuse me for the interruption.
It's quite all right. Mr. Fraser, I think if we could now pull up R of 156. Now, this is dated 6 June 2016. My memory serves me well, roughly 3 weeks after the question. You've had a chance to read this letter recently, have you?
Yes.
And the statutory phrase special public purpose road does not appear in his response, does it, sir?
It does not.
Did you have any further conversation personally with the mayor about his choice of words and the lack of any reference to public special purpose road?
I didn't have any conversations myself with the mayor about this. I'm sure Mr. Sikora would have done. Well, I imagine he would have done.
He reported in his response here that, well, I'll ask it this way. Did you understand him to be describing the historical uses of the road?
Yes, I did.
And he noted in particular, the village of Smilno is not the owner of the above mentioned field track. Is that right?
That's correct.
Now, the topic of special public I'll call it PSPR. It seems to work better. You know what I'm referring to when I say that. That topic had arisen after there had been problems in blockages of the road. Is that correct?
That's correct. We understood the road was publicly accessible.
And by May of 2016, you had decided that an alternative approach to the public road concept might be helpful, correct?
I wouldn't describe it as an alternative approach. I would describe it as an additional approach. But yes, we did think that we needed to do something else.
All right, well, let's take a look, if we can, at some of the events from the time that are documented, which may be helpful. Could we pull up, please, the C-105? I'll ask you if you recognize that document, Mr. Fraser. This is a purchase contract concerning, if we have the right document here, I think we do, the 1/700th share in the road purchase.
Yes.
Do you recall that transaction?
Mhm.
Was that a yes?
Yes, sorry.
And how did that particular transaction come into discussion? This is dated 17 December 2015.
That transaction came about because we were already blocked on the road at Smilno from about middle of December. And our lawyer considered that one of the reasons, one of the grounds on which we were being blocked was that we would, or that it would strengthen our position if we could also buy a share in the road at the same time, in addition to our existing rights.
And that transaction went forward pursuant to this contract, correct?
It never actually went forward. It was blocked, but the contract was signed.
It was declared null and void by the court, correct?
That's correct.
And that null and void judgment by the court resulted from a recognition of claim by AOG, did it not? Yes or no?
Sorry, that is correct. We decided it was no longer worth contesting that claim.
And I'll confess that in the US, that is referred to as a confession of judgment. Do you have something comparable to that in the UK?
I'm not aware of that phrase. I've heard of people just saying we can concede the claim, but
And the claim was conceded in its entirety at a much later point in time, correct?
correct, in June. We applied to concede the claim in June.
So in December, when this transaction was executed by the parties, the intention was to transfer an interest in the road in order to establish access rights to the road, correct?
Yes, additional access rights, if you like.
Now, take a look, if you would, please, at R036. Do you recognize this document, sir? My understanding is that it is the demand letter served by AOG's lawyer upon Mrs. Viriana calling
Yes.
upon her to move her vehicle.
Mhm.
You
Yes,
recall that?
I've seen the document, yeah.
Now, as you look at this, you scroll down beyond the demand to move it within 3 days. You can see there the basis for the demand, can you not?
Yes, I can see that.
And the basis for the demand is the purported rights of AOG as a co-owner of the property, correct?
Correct, that's what it says, yeah.
And it is true, isn't it, Mr. Fraser, that there is no reference to any right other than the claimed right as a co-owner? Yes or no?
Yes, that's what it says there.
All right. And then shortly after that, AOG repeatedly, or even up to that point, AOG had been repeatedly moving her car from the access road, correct?
We had moved it a number of times. I mean, we understood the road was publicly accessible. We were not relying just on our right as a co-owner.
But in the demand, it quite explicitly was reliance on the status as co-owner and nothing else, correct?
Correct, the demand says that, but we had conversations with the mayor, for example, who said you have a
Excuse
right
me,
to go through.
Mr. Fraser, I really would appreciate, our time is
Sorry.
quite truncated. Now, after that, you had also gone to the police, correct?
That's correct.
Based upon her interference with your right as a co-owner, and that is how it was described to the police, is it not?
I can't say.
Well, let's take a look at the AOG report to its partners in C-120. Next page, please.
I'm sorry, what date is this report?
This report is dated on the first page, 21 January 2016. Status update and activity summary, if you.
Yep.
All right. Now, I want to call your attention in particular to the paragraph under issues and give you a moment to read that. Could I ask you to read the sentence for the record, beginning with the word "we"? It's about 6 lines down.
We are working with our attorney, security, construction company, and the local police to repeatedly remove the vehicle.
In the next sentence,
She has legal rights to park her car on the road.
and then there is an assertion of privilege. Just for purposes of our record, Madam President, I'm going to try and forgive my cumbersome approach to this. It's a little tricky sometimes to set the stage properly. So it would appear that the sentence that has been blocked relates to the prior sentence. Do you happen to recall that?
Sorry, can I just take a moment? That trespasses on the legal advice that was provided, that has been redacted. So asking for him to comment on the relationship between one sentence and then the redacted advice would be covered by privilege. So we would object to that question.
So the redacted sentence refers to legal advice given on about her right to park.
Sorry, no, that's not what I said, but asking for him to comment.
No,
on-
I understand what you
Yeah.
said. I'm just asking a little further
Yeah.
because when I saw that, I was somehow
no.
annoyed because I would very much
Of
like to understand what is in this sentence, right? But of course, if there is a legal privilege invoked, then that's it. But you're saying this is redacted because of attorney-client privilege being invoked here.
That is my understanding, and that this document was then, of course, shared with the joint venture partners who had a common interest in that advice, given that they were AOG's joint venture partners. So that's my understanding of why the document has been, that sentence has been redacted.
Thank you. Mr. Alexander, where do we go from here?
Well, let me ask another question, and I understand the position, and we may have further conversation about that at an appropriate point, but I don't want to take too much of my time on it at this point, if that's all right with the president.
That's sure.
Mr. Fraser, the word in the prior sentence that the vehicle had been repeatedly removed, was that consistent with your understanding?
I certainly understand that it was removed more than once, yes.
Okay.
You said a number of times
Yeah.
before
Yeah.
I mean, verbatim.
Yeah.
Right. And on the comment, she has legal right to park her car on the road. Am I correct that you're going to assert privilege for any further discussion about that point?
I mean, I don't know what the redacted words are, so I'm not
I,
sure what I'm
I
arguing to that.
understand.
Can I just ask a question? I really didn't understand this passage because on the one hand, you say you removed the car, and on the other hand, you say she has a right to be there. So what is it? Why
Um,
did you remove the car if you are aware that she has the right to park?
It's not, I will be honest, it's not 100% clear to me. We were told we were allowed to remove the car. I believe we were authorized by the mayor and the police to remove the car. So she may have had a right to park the car, but not blocked the road. I don't know. It's not totally clear, I agree.
Had you seen this document before this arbitration?
Yes, I had, yeah.
Okay. Because I'm staying away from anything to do with privilege. But a minute ago, you said I don't know what the redacted words are. Presumably, I don't know if you recall the redacted words, but you would have seen the redacted words.
I would have seen them, that's
Very
right.
good. Thank you.
All right, I'm going to move on to another document. Could I ask the C-125, please, be pulled up? Now, you do recall, Mr. Fraser, that after the repeated removal of her car from property of which she was a co-owner, she filed a lawsuit against AOG. You recall that?
Yes, I do.
And that lawsuit led to a ruling, the issuance of a preliminary measure ruling, which enjoined AOG from that precise conduct. Would you agree?
It enjoined us from going through with the purchase of the share in the road, yes.
Well, when I used the phrase precise conduct, I meant from moving the car.
It- Is that what the injunction says? I can't, I'm not, I can't recall completely.
Well, let's scroll down. Do you see the language? I'm sorry, I missed it there. That was my mistake. Do you see in the paragraph, 4 lines down from the top, the first defendant, that is AOG, of course,
Mhm.
is obliged to refrain from using the real property. And you understand that real property is the field track, which is co-owned by Mrs. Marinova and reportedly co-owned by, at the time, AOG.
Yes, I do understand that.
All right. So it's a dispute between 2 landowners of the property.
Mhm.
Yes?
Yes,
And the court enjoined you both from using the track and enjoined you from removing things placed by the plaintiff on the property, correct?
yes, that's what it says.
And on the next page, you see about probably 15 lines down the language that begins, the plaintiff was never offered the 1/700th share. Do you see that?
Yes, I see.
Was never offered the 1/700th share in common property, which was acquired by the first defendant on the purchase contract, despite the fact that as a co-owner, she has a legal preemptive right to purchase such a co-share in common property. When did you first become aware, sir, that that all co-owners had a preemption right to purchase the offer pursuant to the purchase contract?
I think I became aware in January 2016, probably when the injunction was issued, or actually the injunction was issued in February. So I think I became aware by that time.
Shortly after her application for injunction was filed, you became aware of it, correct?
Yes, yeah.
Right. And AOG appealed Oh, I'm sorry. I wanted to cover one more point on page 3, please. As part of its consideration of the application, the court notes do you see the paragraph 3 there that is discussed? It's a little more than halfway down the page. An employee of the first defendant, that again is AOG. Do you see that?
Employee. So it's in the third paragraph, isn't it?
Yes, do you see that? An employee
Oh,
of the,
there.
yes,
Yeah, I see, yeah,
thank you. Do you know that name?
yes,
And he was employed by AOG?
correct.
And this relates to the investigation file of the police department. Do you see that? Now
I
that,
see, yeah,
that includes, as I understand it, Mr. Jakowitz's report that the vehicle was blocking access and that he cut the anchor change using lever shears and moved the vehicle off the road. You see that?
I see that, yeah.
Did you authorize that to be done? To remove that property, to remove the car from her own property?
I did not,
Do you know who did?
I don't know, no.
Did you voice any objection to that after you learned it had been done?
I didn't. I mean, as I say, we had been told, we had previously been asked, authorized to remove cars from the road by the mayor.
And there is no documentary evidence of that in the record. Would you agree?
I think that's correct.
All right, now if we could go to the next page. Now, do you see the paragraph 3.3?
Mhm.
That is this court's listing of the number of co-owners of the property who had filed something with the court. And in 4, you can see that the court describes it as these co-owners stating that they have no reservations and agree that the co-owner, the plaintiff, may use the said property to park the motor vehicle that she uses. Do you see that?
Yes, I can see that.
And they go on to say that they had not given their consent to any co-owner to remove or relocate the parked motor vehicle. You see that?
Yes, I can see that.
All right, now if we could go. Well, before we turn to it, do you have any recollection of the court expressing concern about the use of self-help?
No, I don't.
Can I just come in here? It's just a quick question that cuts across. You've mentioned many times in the course of this morning and also in your first and second witness statements, recourse to the mayor. I'm just curious, on what basis did you proceed in that way? I mean, was it on the, again, I'm conscious, I don't want to pry into legal advice or anything, but why did you keep going to the mayor for assistance and advice? And I ask that question because I spent half the year living in a small village in which there are many issues involving the mayor. I think we're all aware of that kind of relationship. So why did you keep going to the mayor on these issues?
The mayor was supportive. He was keen to see activity in the village. He gave us the assurance that we could use the road in the first place. So when we later had problems, we did try and involve the mayor, yes.
But on what basis does a mayor have a right to determine who can and cannot use a particular road?
he represents, I mean, I think our thinking was that he represents the with his council, he represents the village, and he can speak for his council. So we assumed on that basis, we knew he didn't own, the council didn't own the road. But we assumed that his statements gave us the authority, were good enough for us, if you like.
Even when it became clear that his views were not in, should we say, coherence with some of the residents of the village.
I would say that our feeling that it was a very small number of residents who were not supportive, and that the majority of the village, we felt, we understood, was very keen to see us come and commence operations in the village. They're very keen to see us, explore. So I think we felt that the mayor gave us comfort and authority, and we thought we had the support of the rest of the village.
And what was the nature of the relationship with the mayor or the council? I mean, were agreements entered into with the mayor or the council? Were there any financial transactions with the mayor or the council?
No financial transactions. We presented to the council. We presented to a public meeting at their request. We did support the odd initiative of the village, which was, for example, we sponsored a football club. I think there was something else, the Christmas party, something like that. We were keen to show that we were willing to put some money into the village. At that stage, it was just small gestures. But we understood that as an oil company, you need to give something back, and we were keen to demonstrate that, and that would have been part of the dialogue with the mayor.
And did you personally meet with the mayor?
I did, yes.
On how many occasions? Approximately. I mean, it's a long time
yeah.
ago.
I would say 4 or 5. At that stage, most of the conversations were actually in Slovak. So it was tended to be my Polish or Czech colleagues who would have the conversation with him. I didn't realize he spoke as good English as he seems to.
And on the basis of your personal engagements with the mayor, did you form a view as to what motivated his support for this project?
He was, I believe, very keen to see investment come into the region. They were losing their young. The young were leaving the region. They were going to Germany, to Western Slovakia. There's a big concern about the region dying, and he wanted to see any foreign investor come in. I think there was a lot of people knew about the historic oil exploration. They knew where they were. They knew there had been interest in the past, and the people we spoke to were keen to see that looked at again.
Thank you very much.
Any follow-up?
Sure.
Gabrielle? Not at all surprisingly, Professor Sands has put his finger on, I think, an important issue. He asked you why did you, again, you writ large, repeatedly go to the mayor with respect to the question of access and the road. And I understood you to say that you believed that he was able to speak for the council and the village. Did I hear you correctly?
Correct. Yeah.
What I'd like to know is, did you believe he was able to speak for council and village as to the desires of the village, or that he was able to pronounce on the legal status of the road? They're two different things.
We believed he advised us on the legal status of the road. The advice he gave us that it was a publicly accessible road was advice we relied on. It's true, he was not a lawyer. We knew that he was personally supportive of our activities in the village, but at the same time, he made clear he didn't want to speak for the village as a whole. He believed the village was supportive, but he said, you're going to have to go and convince them. I'm not going to do it for you.
All right, thank you. I'll leave it there. Thank you very much.
Mr. Fraser, just following up to the tribunal's questions. You do recall, however, that when he responded to Mr. Sikora's letter, he offered no comment on the statutory public PSPR issue, correct?
That's correct, yeah.
And if I could ask you now to look at R150. This, as you will see at the top, appears to be a report of the district prosecutor's office in the nature of a police report, district police department. Do you recall that AOG had filed a criminal complaint against Mrs. Viranova?
There were a number of complaints going in both directions. I recall that. The details of the individual complaints, I must admit, I don't recall.
So let's take a look. I won't take the time to walk through that point. The document, of course, will indicate, as I suggested, that it was a criminal complaint by AOG. So I'm just going to move on to that. But would you agree, and take whatever time you need, because this is an important point, Mr. Fraser, that the claim allegedly infringed upon in this criminal complaint is solely that of a co-owner, and there's no reference to any public right infringement. As I say, take whatever time you need.
Yes, I can see that.
All right. And then if we could turn down further on the page, please. Over on page 2. If you could take a look at the third paragraph and read that, please, for the record, beginning with only.
Only the relevant court is competent to resolve the property relationship and to decide on legitimacy of entitlements of the specific persons to the specific parcels of land. Moreover, only the court is competent to uphold the validity or existence of the lease agreements.
Do you remember being advised that that was the response of the police department to your complaint?
I don't remember the specific details of the response. I think I remember that that they were not helpful.
Well, you do remember that AOG had filed a criminal complaint
Mm.
based on its co-owner status against another co-owner, correct?
Yeah.
It was a classic land dispute, a civil land dispute,
Mm.
correct?
Yes.
And a few days later, actually a few days previously, Mrs. Viranova had filed a complaint and sought an injunction. And then a few weeks later, that injunction was granted, correct?
That's correct.
And it's also true that AOG, in contrast, did not file for any affirmative relief or any injunction. Isn't that true?
That's true.
In
Well,
fact,
sorry,
the first,
we did challenge the injunction, obviously.
yes, you filed an opposition to the injunction, and we'll come to that in a minute. But on the question of whether AOG had any right, co-owner, public, PSPR, Sesti Smilno, AOG waited 7, 8 months before it ever asked a court to decide the question, correct?
You're referring to the hearing and our appeal against the injunction.
Actually, I'm referring to the fact that in December of 2016, after all the road blockages, after all the protests, after all the criminal filings, the first time AOG filed any affirmative relief was in December, in which it sought an injunction expressly premised upon the PSPR theory.
That's correct. We had relied on publicly accessible initially.
Well, in fact, we've just looked at documents which make it clear that you did not rely on publicly accessible originally in the complaint you filed with the police. It was limited to co-owner status on the 1/700, correct?
That's correct, but it didn't mean we abandoned our view about public accessibility.
But it is clear that although you say now you didn't abandon it, you didn't do anything about it affirmatively until December of 2016.
Yes, that's correct.
The only thing you did was to continue to try to have protesters arrested while they were on the co-owned land owned by Mrs. Variana and other residents of Smilno.
I mean, in June, for example, we were told by the police to have the car towed. So there was a lot of ambiguity about, we were getting mixed messages from the authorities about.
Mr. Fraser, again, our time is limited. I think it's fair for me to ask. I won't interrupt you, but I think it's fair for me to ask a question, you to answer that question. I'm going to repeat the question. After the police said only a court can decide this dispute, you opposed her injunction in the Court of Appeals, and the Court of Appeals affirmed the injunction, correct?
That's correct.
And that injunction remained in place for the balance of 2016 and beyond, correct?
That is correct.
And the only time AOG took affirmative action to establish its right was when it filed a complaint in December of 2016, after her injunction had been in place throughout that period, correct?
You're talking about affirmative action through the courts.
Yes.
We had conversations with the police before then.
Yeah, I understand, but that's why I asked the question the way I did.
Mhm.
So is our record
That's
clear that you did nothing in the courts until December 2016?
That is correct.
And I'd like to put before you what was filed at that time. If I could call up R059. You have that document before you, sir?
Yes,
And do you see the date on that document,
I do. It's March 2017.
right? And it refers somewhere in the text, in paragraph 8, I will represent to you, and you're welcome to pull it up, but just in the interest of time, by request of 2 December 2016, the claimant, you are the claimant in this action, correct?
Mhm.
You sought an injunction ordering the respondents to refrain from, including third parties, any actions leading to restriction of the claimant's access and access of persons authorized by the claimant. You recall that being the purpose of the injunction you sought?
I do.
And you, on page 3, we can turn to that. It says in just before paragraph 9. Actually, about 10 lines up, the claimant justified its request by the fact that the claimant was the entity authorized to carry out the geological survey. And then the court noted that the last blocking had occurred on 15 to 17 November 2016. And then if we could turn to paragraph 11. I'd ask you to read that if you would, please.
In the request for interim injunction, as well as in the appeal, the claimant supports its statements on the right to pass through the access field road by foot and motor vehicles, also by the fact that the access field road is a public special purpose road.
This was the first time you asked a court to consider the theory upon which you had been relying since May of 2016. Is that correct?
That's correct.
And the court denied your request for an injunction, did it not? Both in the court of first instance and in the court of appeals.
That's correct.
And in your witness statement, your two witness statements submitted to the tribunal, you made no mention of this application and this ruling, did you?
I did not know.
And you never told the police about it either, did you, sir?
I'm sorry, told the police about this court process?
Yes. Yes or no?
No, we did not, no.
And you never told any of the ministries you contacted from time to time about this ruling, did you, sir?
I don't believe we did.
Now, Mr. Fraser, this ruling raised two, I would submit respectfully, insurmountable problems to your use of the PSPR theory that is at the heart of this case, didn't it, sir?
Sorry, you were saying it raised two obstacles, you say?
Yes. Number one, it denied the injunction.
Yes.
And it also said that the PSPR theory that you were proposing failed to take account of the rule that a user pursuant to a PSPR theory must accept the road as it is. You remember that, don't you?
I don't remember it now, but it's in the judgment, is it?
Yes, it is. Look at paragraph 13, if you would, please. The underlining is, I believe, in the original of the court. Could you read, just for our record, beginning with the word users?
Users must adjust themselves to the construction condition and transportation technical condition of the roads.
Now, Mr. Fraser, that was a huge problem for AOG, wasn't it, sir?
At this point, which is early 17, we had adopted a slightly different strategy. So we were not less focused on the judicial process with the road at this point. So, yeah.
But you were still relying on law, were you not, in your activities at the site?
Of course, we were relying on the law, but we were by then in dialogue with the activists behind this lawsuit, with this litigation. And our understanding was that if we could reach an accommodation with them, then they would no longer block our access along the road.
And we're going to come to that in some detail, Mr. Fraser, but for now, I want to just understand. First of all, would you agree, Mr. Fraser, that it would be fair to bring to the tribunal's attention a ruling directly on the issue of the PSPR theory, since it is at the heart of your claims here?
We didn't. We didn't think it was relevant by then, because, as I say, the debate had moved on.
So your testimony to the tribunal is the fact that a court made the ruling it did about the your failure to carry your burden of proof on the establishment of the PSPR theory. You didn't think that was warranted. I'll move on.
May I ask a question before you do, sir? If I understand your testimony, Mr. Fraser, you say the debate had moved on or circumstances had moved on because you were in discussions with the activists. I think you said a moment ago. Is that correct?
That's correct, yeah.
And you were in discussions with the activists about removing their blockage.
Correct.
Okay. My question has nothing to do with that particularly. Did you, again, the company, or you personally, understand that discussions with the activists, as you call them, could resolve the particular question of having to use the road in the conditions in which it was at the time? In other words, could the activists allow you to gravel the road? Was that your understanding?
Our understanding was that if the activists could be placated, that they would have no objection to our using the road, and I'm sure that that would have included upgrading or maintaining the road if required.
And I don't, well, I don't know what your answer will be, but was it the company's understanding, as far as you're aware, that with, let's say, the blessing of the activists of the local community, to upgrade the road to the extent required for proper access, that would resolve the issue that that Mr. Alexander pointed you to, where the court seems to have said, as a PSPR, you must respect the conditions of the road as you find them? Or again, I mean, this goes, excuse me for not just interrupting your answer, but for complicating the question. This goes to the dichotomy that we were discussing a moment ago between the politics and the law, if you will.
Yeah. I mean, I would first of all distinguish between the activists and the local community. We did not see them as the same at all. They were quite distinct entities, groups of people. But yes, we thought that if we could address them on the concerns which they were very vocal about, they assured us that they would not then, they would let us have a clear path at that point. So maintaining the road, I think, was a detail in that bigger picture, I'd say.
Thank you. That's helpful.
And Mr. Fraser, it is, as you suggest, important to pay attention to the chronology here. We circulated a demonstrative exhibit. Madam President, we may be continuing to move through some other documents as I use this, and I wonder, would it be helpful if I gave you a copy of this and the witness so that we could have them both at hand? I think it might be easier to read documents and put it in this chronology.
That's certainly fine. We have been going for an hour and a half now, so I'm wondering whether this would not be a good moment to have a break before you going into these questions. Does that make sense?
That's fine, Madam President. Thank you.
Good.
Madam President, just one question. Would we be able to see a copy of that chronology before the break, just so that we are able to see the document?
It's been circulated.
The demand.
Yeah, it's one of the.
I
draws.
understand that it must
Yes.
have been circulated
Yes.
because that's the rule, right?
Please forgive me. I
Yes.
thought this was a new document.
No, it's not.
Number, just for my information. Which demonstrative?
It's RD.
Thank you.
So we're going to take a 15-minute break now. During the break, Mr. Fraser, please do not speak to anyone because you're on the witness stand. Good, thank you. So before we start, we just received an email.
Yes.
Can you just explain what it is and the context?
Yes, Madam President. So it relates to the cross-examination that Mr. Alexander was pursuing in relation to Exhibit R155. During the course of the break, we obviously checked whether the attachment that was being referred to was within the legal team's possession, and it was discovered that it was. The explanation for why it wasn't originally disclosed in response to Slovakia's production request was because a number of documents were sent, they're originally in Slovak, were sent to interpreters in order to conduct a review as to the relevance of those documents. This document was unfortunately by human error missed from that set. And so therefore it wasn't picked up in the disclosure review exercise. We don't have an original, an English translation now, but we're obtaining one. And so therefore we've given it to you as soon as we were able to find out the position. So we apologize for the error that originally occurred, but that's the explanation.
No, we appreciate the explanation and the fact that you're submitting it.
So it's not privileged?
And it's not a privileged document, no.
There you go.
Okay,
Thank you.
thank you.
Mr. Alexander, did you note this? Oh,
You're
hi,
reading
Rusty.
it.
Examiner of the content of the document.
Are there any comments you wish to make now or later on the document? Yeah,
Yes, Madam President, I don't speak Slovak, so I would like to read it, and that does raise the question of timing
Yes.
and our time. With the tribunal's indulgence, I want to just confirm that we would be permitted. We have 2.5 hours for each witness, estimated. It may be appropriate, given the pace, for which I accept responsibility, that we readjust that somewhat. And would that be acceptable to you?
no, the tribunal's view is that you're not held to the time estimates, you're held to the total time allocated over the entire hearing.
Yes.
Obviously, if we can stick about to the times indicated, that allows us to follow the sequence of witnesses as they are organized for each day, but we have some flexibility. So that is not a problem. The question I was asking myself is if you need to have a translation and then you may still have additional questions for Mr. Fraser, that might have to be after the lunch break, which would imply that Mr. Fraser remains sequestered during the lunch break. That's the only timing issue I
Yes.
really see.
Thank you, Madam President. Yes, we based upon the preliminary description I've received, I will want to ask some questions for it.
Fine. So let's proceed now with
Yes.
the other questions and then we'll revert and see what time we get to it.
Yes, thank you, Madam President.
may I just raise a practical point? You're going to, Mr. Alexander, you're going to have, if not a translation, at least a fair description of the document. I just want to be certain that if and when you put questions to any English-speaking witness, whichever witness that might be, that the witness also has access to some form of English description or translation so that the conversation can go smoothly. Ah, fine. I didn't know if it was on you or the other side, but That's very good. Thank you.
As soon as we receive the interpreted translation, we'll send that through. And we hope that will be able to be done as soon as possible.
So we'll soon have two translations, if I understand it correctly. So
Right,
we couldn't wish more. That's fine.
very good.
May I proceed?
Yes, please.
Thank you, Madam President. Mr. Fraser, you may recall I had earlier asked some questions about whether the Court of Appeals decision on your injunction application against Mrs. Viriano and 4 or 5 other parties, whether it created some insurmountable problems. Probably should have said serious issues for AOG going forward. Do you recall that?
Yes.
I wanted to address one other matter that was raised in the court's decision. And if we could pull that up again, maybe it's already up. That's R59, yes. Do you recall the court's discussion about the constitutional rights of Mrs. Variana and the other landowners?
I do.
And do you recall the court's conclusion that the impairment of her rights to usual the impairment of usual ownership rights could only occur in the event compensation was paid, and that there was no evidence of record that compensation had been offered? Do you recall that discussion?
I'm sorry, is this in the first decision or for an injunction or in the appeal? This is
The appeal.
This is in the appeal, right?
Do you remember that?
I don't recall that.
Well, in fairness, let me find it for you. If we could look at paragraph, page 7, paragraph 28.
Page 7 of my first witness statement.
Beg your pardon?
Page 7 of my witness statement.
No, this is
Oh.
of the exhibit
Okay.
on the screen, R59. I'll point you to 2 or 3 sections of this discussion about constitutional impairment. Towards about 10 lines down from the top, there's a sentence that begins, with regard to the above, we can conclude that the only interpretation conformable with the Constitution is that the landowner should consent to such a restriction of ownership right, in addition to consent of the owner, that is necessary. Existence of an irreplaceable necessity to communicate is a precondition for private land use by the public. And then further down, do you see the line, maybe 12 lines up, after the notation, the owners, a public accessible special purpose road may be established also against the landowner's will, only if compensation is provided to the landowner. You see that? That's the point I'm identifying.
Where is that?
It's a little bit up from 29, a publicly accessible special purpose road. You see that?
Sorry. I see, yes.
Yes. You recall being made aware of the fact that the court had said any such statute would need to be construed in a way that if there was a forced restriction, compensation would have to be paid.
I don't recall that, but this was in March 2017, and we were not focused on judicial processes by now.
All right. before we broke, I also mentioned that I wanted to spend some time talking about the chronology of events in 2016. And I've placed before you and circulated to the tribunal and your counsel two documents. One is Respondent's Demonstrative Number 1, and I'd like to ask you a few questions about that first. Do you have that before you?
This is not the timeline, but the AOG's changing justifications.
No, it is the timeline.
The timeline, okay.
Now, we talked earlier this morning about the regional court having issued an injunction against AOG and third persons acting under its authority in February 2016. You recall that discussion?
I do.
And that injunction stayed in place, was not vacated or otherwise modified to the end of 2016 and beyond. You recall that discussion?
Yes,
All right. And you being AOG, and you personally were aware that that injunction remained in place, correct?
that's correct.
And while that injunction was in place and you had unsuccessfully appealed it, AOG repeatedly violated the injunction, did it not? It entered the land from which it had been enjoined. That's true, isn't it?
Well, we maintain that Sesti Smilno entered the land.
I understand what your theory was, but what I'm asking about is the court's order. The court's order never changed, did it?
Correct.
You developed what might charitably be called a new argument, but the court's order never changed, didn't it?
That's correct.
And while the court's order was in place and AOG had not sought any affirmative action on its new arguments, you repeatedly entered the site, correct?
Sesti Smilno entered the site, yes.
Well, Sesti Silmo was a subsidiary of AOG, was it not?
Yes,
Perhaps this is as good a time as any to talk about Sesti Silmo. It had been created shortly after the court had enjoined AOG when its 1/700th share transfer scheme failed, correct?
that is correct.
And it was incorporated and the transaction was put together for the express purpose of circumventing the injunction.
Our understanding was that Sesti Smilno was not bound by the injunction.
That's not my question. AOG was bound by the injunction, correct?
Correct.
At all times to the end of 2016 and beyond, correct?
That's correct.
AOG caused the creation of Sesti Smilno, correct?
It did.
It was a subsidiary of AOG, correct?
It was
It had no assets of its own, did it, sir?
very small.
It had no employees.
That's correct.
It took direction entirely from AOG, correct?
It had the same direction as AOG in the sense of the same managers. That's correct.
Mr. Fraser, I mean this with respect, but do we really need to take time here talking about whether AOG controlled Sesti Smilno? There's no question about that, is there?
I agree. Sesti Smilno.
That's all I need. You agree that it took direction from AOG and AOG alone, correct?
or let's say it acted in collaboration with AOG.
Well, it had no persons controlling it other than AOG, did it?
The same people as controlled AOG, yes.
Exactly.
Mhm.
It had no directors and officers of its own, did it, sir?
They were the same, they were some of the same individuals.
Right,
but-
it was its alter ego. We all know what that means.
Mhm.
You agree with that, don't you?
As I say, it had some of the same management as AOG.
Well, was there any management that wasn't AOG?
I don't believe so. It had one outside shareholder.
And that outside shareholder was the party who, at AOG's suggestion, had contributed its share in the road for the purpose of circumventing the injunction. That's rather obvious, isn't it, Mr. Fraser?
I mean, the structure involving Cesti Smilno, yes, it was a way to enable us to carry on operations which were not in breach of the injunction. That's what we understood.
But if AOG instructed Cesti Smilno, its 100% owned subsidiary, to pick up heavy equipment and move it across the road,
Mm.
you don't contend, do you, that that's not the action of AOG, do you, sir?
I mean, that's a legal question.
No, I'm not talking about law at this point. I'm talking about factually.
Mm.
If somebody in management in AOG picks up the phone, there's no one on the other end of the line. All they have to do is take the phone and turn it over here. Isn't that right?
That's correct. But as I say, our
Now, wait,
understanding
no.
was that it was not in breach of the injunction.
Now, we'll get to that, but factually, I just want to be clear that Cesti Smilno had no personnel or mechanisms of operation other than what were instructed by AOG. Isn't that right?
That's correct.
Okay. So all AOG actually did was to tell people who were bringing equipment over to the road, come on through. That's all that happened, isn't it?
Cesti Smilno issued authorizations to people to come onto the road.
As a wholly owned subsidiary of AOG. All right. Well, I think we have what we need there, don't we? But you will concede, won't you, Mr. Fraser, that Cesti Smilno had no independence whatsoever from AOG.
It obviously pursued the same objectives as AOG. I agree.
All right. Now, given that, it's also true, isn't it, that AOG never went to the court on an affirmative action to try to legitimize what was going on with Cesti Smilno. All it did was to argue to the police that somehow this changed everything. The rationale had changed. Yes?
That's correct. And we understood that it had changed.
And the net effect of all this was that a share transfer that had only days before been found unlawful, to which AOG ultimately confessed judgment or recognized the claim. Another share transfer was made to Cesti Smilno, which AOG still controlled and instructed. And that's how the road was used by Cesti Smilno, correct?
That's correct.
And that was, if you look at the other demonstrative I've left there on your table, AOG's changing justifications to access the road. Do you see that document?
Yes.
Now,
But for the transcript, we should say it's page 109 of respondent's opening presentation.
thank you, Madam President. I apologize. Should try to do better on that. So that was what you discussed in your own witness statement, correct?
Correct.
And later actually in early 2017, Cessny Smilno also applied for an injunction against Mrs. Variana and other citizens, correct?
That's correct.
But that was not put into the record of this proceeding. Is that right?
For the same reason as the other one, it was not put into the record. That's correct.
So at the same time that the Cessny Smilno share transfer scheme was developed, there was also, as we've talked about this morning, in May of 2016, there was discussion between Mr. Sikora and the mayor, which I refer to here as the Public Special Purpose Road Scheme. And we discussed earlier this morning that the regional court later denied your request for an injunction on the basis of that theory, and that was affirmed, correct?
Mm-hmm. Yes.
So as we look back in time, there were three separate rationales employed by AOG to legitimize its access to the road, correct?
I would add a fourth rationale, which was before the transfer scheme, that the road was publicly accessible. That's on that basis that we entered the road initially.
Right, but that's the same rationale as the third point, isn't it? The Public Special Purpose Road Scheme.
I'm not a Slovak lawyer. All we knew was that we believed on good authority, understood that the road was publicly accessible.
But bearing in mind what the police were interested in was in a land dispute, they wanted, as we saw earlier, they made the point, only a court can decide this. No court ever found in favor of AOG on any theory it proffered to justify its access to the road. That didn't happen. No court ever did that, did they? Did they, sir?
That's correct.
So if we go back in time, every time on the timeline I've put before you as respondents demonstrative number one, every time AOG entered the site or upgraded the site to a condition improved beyond how it was first presented, every time any of that activity occurred, we now know that AOG was never able to sustain any position for lawful entitlement to that access. And to the contrary, it did so in violation of a pending court injunction. Isn't that true?
We don't accept that. I don't accept that because we were attempting to enter the road in June on the basis of Cessny Smilno's authorization, which we've already discussed. And I would also remind you that the police actually authorized us to remove vehicles when we attempted to get on the location in June. So we had, we thought good indications that we were entitled to use the road.
Despite the fact that you were subject to a court injunction, which you don't dispute.
Despite the fact that AOG was subject to a court injunction, yes.
And your position is, as we've described before, that Cessny Smilno, even though it was 100% owned by AOG and directed and instructed by AOG and serving its purposes in its use of the road, your position is you had a good faith basis. Is that correct?
That was our understanding, yes.
I have a moment, Madam President.
Please forgive me for interrupting, but we've just sent you, you should be receiving shortly an English translation of the document. I just wanted to let you know that it's
Thank
certainly
you.
the case.
Thank you.
Mr. Fraser, in connection with the Sesney-Smilno scheme, it is true, isn't it, that the co-owners were not offered the share that was transferred to Sesney-Smilno?
That is correct, and we were advised that it was not necessary.
And you assert good faith because of your reliance on that advice. Is that what your testimony?
Yes, our understanding was that it was not necessary.
But you nevertheless claim privilege over the matter on which you claim legal advice. Is that right?
I believe that's right, yes.
Now, I want to return to your witness statement at paragraph 45, if we can, please. Mr. Fraser, I want to focus in particular for a moment on the events of mid-June. That was a period of substantial difficulty for AOG, to put it mildly. Would you agree?
We were trying to drill on at Smilno.
And you were strapped financially at the time, correct?
No, that's not correct.
That's not correct.
No.
You had been working for more than 2 years to obtain external financing, correct?
Correct.
And despite those efforts, you had been unsuccessful with the exception of the ACARD commitment to fund, correct?
We had secured the ACARD funding at the end of 2015.
Right.
That's correct.
Now, when you say secured, we need to clarify that to some extent, don't we, sir? There was a commitment by ACARD to fund, but the extent of that commitment had not yet been funded, correct?
Not the full extent had not been funded, but a significant amount of funds were being dispersed during that year.
And there were substantial problems during that year in their making funding in response to cash calls, correct?
I don't recall that. They continued to fund us up until the end of 2016.
You don't recall that. Well, we'll come back to that in a moment. But you don't recall difficulties from ACARD funding in the latter part of 2016?
At the end of 2016, there were difficulties possibly coming up to the end of the year. But not during the middle of the year, to my recollection.
Mr. Fraser, it is true that in the early stages of the search for finance, you were looking for between $15 and $30 million, correct? US.
That's correct. At that stage, we were looking to finance both Polish activities and Slovak activities.
And at the time of well, let's see, in the end of 2015, you'd received a commitment to fund by ACARD, but they had only funded by that point in time 1.9 million, correct?
By the end of 2016, that's correct.
Right. And later in that year, their funding problems became severe enough that you actually were not being paid, correct?
By the end of 2016, they refused to continue to fund us because of the difficulties we were facing in Slovakia.
Right, but there's no evidence in the record that they did it on that basis, is there, sir?
I believe the
Could you answer that question first,
sorry.
yes or no?
I thought that there were I think the answer is no, because if I'm not mistaken, there is we served a notice of default on ACARD for failing to fund at the end of 2016 or early 2017.
You served a notice of default on them.
Yeah,
And they threatened you with counterclaims.
they did. Yes.
Yes, including a threat of an internal investigation of possible violations of the Federal Corrupt Practices Act by AOG, correct?
That's what they said. Yes.
Yes. And as a result of settling those claims, it's true, isn't it, that you agreed to pay back all the money that they had funded you?
We did agree that.
And that settlement put very extreme pressure on AOG, did it not?
No, not at all.
You had no funding, you had no external funding at the time, correct?
The settlement was we would repay that money if and when we came into funds in the future. There was no immediate obligation to repay under that settlement.
But you released them from any obligation to fund further.
They had.
Is that true?
Well,
Is that true?
They were in default, so we defaulted them out of the agreement.
And they were released from the obligation to fund any further. Isn't that correct?
Well, once they're in default, they're released. That's right.
And they released you from all potential counterclaims.
So they assert they had no potential counterclaims as far as we were concerned.
And at that point, but wait, they had no potential counterclaims, but you agreed to pay back the money?
We agreed if at some point in the future, if we had the funds, we would repay them.
And when that release was signed, you had no other external financing in place, correct? You were net zero external financing.
That's correct.
And Mr. Lewis had made it absolutely clear that he didn't want to fund anymore, didn't he?
He had made it his strong preference was to fund was to co-fund, was to have someone else come in. He didn't want to fund the business on his own, which is very common for the oil industry.
And towards the time period we're talking about, he'd made it clear that he was not going to fund further, isn't it?
You're talking about early 2017.
Yes.
What we were seeking to do in early 2017 was bring in another investor for part of our commitment. And I expect that Mike would have funded a piece at that point.
But that never happened.
That did not happen. That's correct.
Now let's go back to 2016, in June. You were anxious, notwithstanding the injunction, to just go ahead, correct?
Correct. I mean, one issue was the licenses were coming up for renewal, so we're keen to have some activity before the renewal.
And by going ahead, notwithstanding the injunction, you took a number of aggressive steps. Would you agree, sir?
I wouldn't agree that, no.
Well, you upgraded the road, correct?
We did.
You continued to bring materials to the site over the road, correct?
Correct. We upgraded the road and brought materials on using a local contractor and with, as far as we're aware, the blessing of the mining authority, which came out and inspected our activities on the road.
But you had an injunction against you from using the road, correct?
AOG did,
Yes,
not
That's
Sesty,
what I-
not Sesty Smilno.
right. But Cessny Smilno didn't upgrade the road, did they, sir?
A contractor upgraded the road.
Right. And
Hello?
who engaged the contractor, sir?
I can't recall offhand. I mean, AOG will have paid the bills for the contractor, that is true.
And there's no evidence in this record that Cessny Smilno ever engaged anybody, is there?
That's correct.
Everybody who used the road was engaged by AOG, to the best of your knowledge, isn't that correct? And all of this happened while the injunction remained in place, isn't that right?
I mean, my recollection is that when the contractor entered onto the road, it was with an authorization from Sesty Smilno. As I say, the mining authority were aware, the police were aware, no one attempted to stop us.
You just, same plan, just go ahead.
Well, the only person who had an issue was Mrs. Varianova. The locals in the village were perfectly happy with the work being done to the road.
Mr. Fraser, you sued several other villagers for blocking access to the road, didn't you, sir?
I don't believe any of the others were from the village. They were from somewhere away. Yeah, I think the only person on the in those proceedings who's from the village is Mrs. Varianova, to the best of my knowledge.
Mr. Fraser, you're familiar with the petition activity that occurred in the village, are you not?
Yes,
And the petition was signed by a majority of the inhabitants of the community, was it not?
I believe it was signed by about 300 people.
And that was the majority of the known residents of the community, wasn't it?
I'm not sure it's a majority, actually. The population of the village is about 700. I can also say that I looked down that list of names on the petition, and a number of those people actually signed consents for us to use, for AOG or Sesty Smilno to use that road. A number of people on that petition.
Right, and there's no evidence of that in the record, is there?
I can assure you.
And that wasn't in your witness statement, was it, sir?
No.
Mr. Fraser, after the petition activity by over 300 people from the village of Smilno, the petition was presented to the council of the village, was it not?
I believe it was, yes.
And the council passed a resolution in response to that. Isn't that correct?
Can you remind me of the resolution, please?
I can. Let's start with R109. Before we get into the documents on this point, Mr. Fraser, you've made the statement repeatedly in your various witness statements that it was a very small minority of the village that was opposed to your operations, correct?
Yes,
And you did that based largely on reports from your team on the ground, did you not?
and what I saw with my own eyes as well.
And you did see the petition materials with your own eyes?
I did not see them at the time. I heard about them, but I didn't see them.
Right. Were you receiving reports on this issue from Mr. Crow?
From one of my colleagues, I received reports on it, yes, probably from Macho Carabin.
You don't remember?
I don't remember who from.
Right. So in this petition activity, there were 4 members of the committee. Do you recall that?
Yes,
And 2 were affiliated with the municipality itself. So you have before you the presentation of the sheets of the petition. And then there was activity, 341 signatures of the citizens of Smilno. And then there was a resolution presented to the council. Do you recall that?
I do.
And the council took action on it. Do you recall that?
I don't, to be honest.
All right. Let's take a look at R015. You recall, do you not, Mr. Fraser, that the petition was opposed to the operations of AOG in Smilno? You recall that?
I do. Could we see the wording of the petition, please?
Yes, we can. But before we do that, let's look at the votes taken by the municipal council. Do you see that? I think it was a 4. There were 4 votes of the council in favor, 0 against, and 1 abstention. Do you recall that?
Yes.
All right, now let's go back to the language of the petition. R107. Can I trouble you to read for the record the petition language at the top, please?
We, the undersigned residents, disagree with the activities related to exploration area Svidnik, oil and combustible natural gas, that with their consequences have an impact on the environment in municipality Smilno. We therefore request that the municipal council of Smilno and the mayor of Smilno express their disapproval of exploration area Svidnik, oil and flammable natural gas, as well as of all the geological works in the exploration area and related activities that intervene in or have an impact on the environment in Smilno.
Do you recall the vote we just looked at, which was 4 in favor, 1 abstention, and as I recall, the mayor did not vote, correct?
That's correct.
We'll hear from him later, but do you recall his position essentially being that it was his responsibility to remain neutral?
Yes, I recall that.
Sorry, could you just tell us what it is they were voting for? Because it didn't say on the document you showed us.
The language of the petition itself.
Thank you.
To be clear, Mr. Fraser, our case is not that this was a legally binding event. It was intended as an expression of interest and concern about the activities of AOG. You understood that, didn't you?
Yes.
And I raise it because, as we said before, you and other AOG witness, Mr. Lewis, have taken the position that there was a very, very small minority. And earlier today in your testimony, you said that Mrs. Viriano was the only person who was opposed to the activities of Smilno, correct? You said that earlier.
I think I said she was the only person we brought that I was aware of who was included from Smilno, who was in the lawsuit.
I see, but you would agree that there was a substantial show of concern and opposition to AOG's activities by virtue of this petition activity.
I agree that the petition has a lot of names on it. We don't know how the petition was obtained. And when it came actually to demonstrations or any activity against our activities at Smilno, there were very few residents of Smilno who were participating in that.
How many people showed up for the demonstration in Prešov?
I don't recall precisely. I was there, but my recollection is it may have been. I really don't actually recall. It could 50 or more, certainly.
You don't remember 200 being the number associated with that?
I don't recall.
All right. Back to the June timeframe. I'd like to pull up R122. This is a 14 June 2016 memorandum from Mr. Benada, is that
Benada.
correct?
That's correct.
To you with a copy to Mr. Lewis and Mr. Carabin. This is a communication among the 4 top management people in the company, correct?
That's correct.
And it was at this point in time just a moment, please. May I have a moment, Madam President? That's not. Let's turn to page 3, please, of this document, R122. Do you see the discussion concerning White and Case?
Yes.
It was at this point in time that AOG had begun to consider a potential treaty claim, correct?
Not at all. No.
Isn't that what's being discussed in this memorandum?
Well, there is a comment there about a description of conversation with White and Case. I had been asked to, just to find out. Sorry, I'll take a step back. There was some concern as the licenses were being renewed that there might be opposition from these activists who are becoming so very vocal, and there was a concern that our licenses might not be renewed.
But they were renewed.
They were renewed, but we didn't know that at this point. This was in June. So we did, just as a precautionary measure, just think about, because we had an investor after all at that point, think about whether or not we should, what any recourse by way of arbitration might be. That line of inquiry was nothing more than that conversation with White and Case, and it went nowhere and was dropped, and the licenses were renewed shortly thereafter.
Well, let's talk about another event that was in the backdrop to the June events. The Court of Appeals had found that AOG had acted with mala fide in its conduct in relationship to the local community, correct?
Are you talking about the appeal against the injunction?
Yes,
They didn't use the words mala fide, did they?
yes. Let's turn to R63. Page 6.
May I close R122?
Yes, you may.
Thank you.
I'm referring in particular to the 3rd paragraph. Could you read that, please, sir, at the beginning with as to?
Third paragraph begins defendant 1.
Yes, that's AOG.
So defendant 1, you want me to start there? Defendant 1?
That's fine.
Defendant 1 must have expected from the very beginning that a legal construct allowing it to carry out geological exploration on a third-party land through a already invalid purchase of a tiny co-ownership interest may fail. As to whether defendant one acted in good faith, it can be reliably stated that the conduct of defendant lacked elementary caution. Defendant one could have been well aware that purchase of a minuscule co-ownership interest without respecting the preemption right is very close to violation of ownership rights. It is evident that business activities of defendant one were based from the very beginning on a mala fide manner of communication with owners of the affected land. From such a point of view, the conduct of defendant one lacks any bona fide trait.
And after that finding was made, it is true, isn't it, that AOG submitted its recognition of claim?
It is true,
That's all I need.
that's true.
You submitted a recognition of claim, and the effect of that was a declaration by the court that the 1/700th share transfer scheme was null and void, correct?
That's correct. We conceded the claim in order to have the interim injunction lifted.
But that didn't happen, did it, sir? That injunction was never lifted, was it?
It was in 2017, finally.
After all the relevant events had transpired and you had been consistently going and using the land in violation of the injunction. We've already established that. But what else was happening, Mr. Fraser? There was the share transfer scheme was the foundation of Cessny Smilno, as we've already covered, correct?
Yes,
And we already covered the fact that there was no offer of a preemption right as part of that scheme, although that conduct had previously been found unlawful, correct?
we understood that there was, that's not, it's correct that there was no offer of a preemption right because we understood it was not required.
And later, you proceeded to argue the Cessny Smilno scheme and the PSPR scheme to police, to the prosecutor, to various governmental authorities, despite the fact that those cases were never prosecuted for a judicial determination until many months later, correct?
Our objective was to get the interim injunction lifted. That was our priority. That's why we conceded the claim, or dropped the case, sorry, the claim. Yeah.
So if you look again, Mr. Fraser, at the document marked AOG's changing justifications to access the road. You have that in front of you?
I do.
It is true, isn't it, that these schemes occurred over a chronology of time? Is that right? In other words, the 1/700th share transfer scheme came first.
As I say, as I've said earlier, we originally accessed the road on the basis that it was publicly accessible.
But no document that you submitted to court is consistent with that statement, is it, sir?
I believe there's a memorandum or a record of a meeting with the mayor in 2015 where we discussed use of the road.
You may recall my question was directed to submissions to a court.
I apologize. There are no submissions to the court, that's correct.
And the Cessny Smilno share transfer scheme came within days of the court's ruling on the first scheme, correct?
It came shortly after, that's correct.
And it also involved a shared transfer. Correct.
It did.
And then the public special purpose road scheme we saw earlier began with the discussion with the mayor. You recall Mr. Sikora's
Mhm.
letter to the mayor.
Yeah.
And with that,
My recollection is that with Mr. Sikora, we were discussing public special purpose road at about the same time as we started the Sesti Smilno structure.
Madam President, I wonder if this might be, I apologize for taking a break prematurely, but I wonder if this might be an opportune time to look at that translation. And then I could perhaps streamline what I have left at the same time, which might have value.
How much time do you need for that?
Would 15 minutes be acceptable?
Yes.
Thank you.
What we might then do is shorten the lunch break somewhat. So we will not take the lunch break now. I don't think that is your suggestion, right? Then we try and wrap up the examination of Mr. Fraser before the lunch break. I'm not sure that will be possible because it also depends on redirecting tribunal questions. But we go as far as we can. And
I just to be fair, I'm not sure that I will be able to wrap up before lunch with Mr. Fraser, but I realize that
that confirms my doubt then.
Yeah.
My doubt was on other grounds, but yeah, it reinforces it. Let's take 15 minutes now.
thank you very much.
Good. And Mr. Fraser, you know, you're still under the same admonition.
You should have received it. Of course, we have no objection to that.
Yeah, can we restart and then we do this on the record so it's clear what we're doing? We understand now that the new version of R55 was attachment and specifically the translation as it was provided by the claimants, but then was a correction by Mr. Bekash, will be filed by the respondent as a new exhibit R155A. Is that fine?
That is acceptable to the claimants, yes.
Good?
Thank you.
So, Mr. Alexander, whenever you're ready,
All
you
right.
can proceed with your additional,
All right.
your questions.
Got it. Okay. All right. Thank you, Madam President. Thank you, Mr. Tushingham. Glad we were able to get that worked out. Thank you. Mr. Fraser, on the screen, momentarily, we will have the new exhibit 155A, the revised exhibit that just reflects the agreement of council and Madam President's comments. Just going to wait for the document. Madam President, I understand the Document's going to be available momentarily. All right. Thank you. Mr. Fraser, just to explain what has transpired here. This is the attachment to the earlier exhibit 155, which you'll recall was the letter from Mr. Sikora to the mayor.
Mhm.
And these documents were attached to it. And I want to give you a fair moment here to read them both.
Mhm.
And then when you've had a chance to do that, just let me know and I'll have a few more questions for you.
Can I page down?
Mr. Fraser, does seeing these documents refresh your recollection at all about whether you saw the attachment before the actual material?
I don't believe I did see these attachments before.
All right. Bearing that in mind, would you agree that these appear to be a letter from Alpine to the mayor? That one, of course, is bears a signature line for Mr. Bonata. Do you see that document?
You could scroll up, please. Yes, yes, I see.
All right. And you've had an opportunity to read that.
I have.
And in that letter, Mr. Bonata has asked three specific questions. Is the aforementioned field road a public or non-public special purpose road? Is the town of Smilno the owner of the above mentioned special purpose road? And who is responsible for the management and maintenance of this special purpose road? You see those specific questions?
Yes, I do.
And then the second portion of the attachment is what I understand to be a draft letter proposed for signature by Mr. Barrett, which draft as part of the attachment was forwarded by Mr. Sikora to the mayor. And it proposes a draft response to the draft letter. Do you see that?
I do.
Now, if you would turn, please, to 156, R156, which should be coming up momentarily. I'm sorry, I may not have spoken clearly enough. We're trying to pull up R156.
I'm sorry.
My mis-
Soon stop sharing. Stop sharing when I change the system.
Sure.
One second.
All right, now we took a look at this before, but now that we have the benefit of what the attachment included, And if we could just trouble you to scroll down so that the witness can see that that is the entirety of the substance anyway of the letter. So this is Mayor Barron's actual response. Is my understanding. Do you agree?
Yes.
All right. Now, it's apparent from that response that the mayor responded only to the second of the three draft questions. Would you agree?
Is the second one about who is the owner of the track?
Yes, yes. The town of Smilno is not the owner of the above mentioned special purpose road.
He's only responded directly to the second one, I agree.
Yes. And he did not ever use the phrase public special purpose road in his response, did he, sir?
He did not.
And there is no response to either the first or the third questions drafted for him by Mr. Sikora. Would you agree with that?
I would think that the first question is meant to be a response to his other two questions.
Could I just ask, just in relation to this document and the previous one that we just looked at, 155A, I think it is. 155A has the first page, which is the request. And the second page, I assume, is drafted by AOG. Am I right in thinking it's drafted by AOG and is the response that was requested?
That's my understanding.
Is that correct?
I don't know the answer to that question, I'm afraid.
It's just that in relation to the answers to your questions, it's and I assume you're getting there, it's the relationship between the answer that was hoped for on the one hand and the answer that emerged on the other, but we don't know what the second page is that right?
I don't know the answer to that question.
Because the witness, I believe, said, excuse me, he hadn't seen these
Yes.
at the time.
Yeah.
He said, I thought he'd said he doesn't recall now having seen them.
I don't mean to put words
Yeah,
in anybody's
right.
mouth. Maybe you want to clarify that so that I'm not mistaken?
He's, and you correct me, you said you believe you have not seen them.
Correct.
Then.
Very good. Thank you, madam.
Mr. Fraser, you may recall we looked at your name at the top of the email and you, is that a yes?
Yes, sorry.
And your conclusion from that was that, and you recalled being copied on the email, correct?
I don't recall being copied on the email in that my name is not in the CC line. It's possible that he may have sent me the email afterwards, similar to a BCC, I guess.
But you don't dispute that you were in the loop on this discussion.
I don't believe, I believe I was in the loop. Certainly I was well aware when the letter came back from the mayor.
And there's, I believe, agreement by council in our submission of this new exhibit that both of these, both the questions and what appears to be a draft response for the town of Smilno were the attachment.
Oh, I'm sorry. We are talking at cross purposes. We accept that that was the attachment to the email.
Yes.
Forgive me if we've misunderstood that. You've misunderstood what I
Yeah.
said.
Okay.
So, but I think I may have misunderstood your original question or Mr. Sands' question, which was, do we know that AOG drafted that? And I don't know the answer to that question. But of course, we accept that this was the attachment to the email from Mr. Sakura.
I mean, it gives the impression of being the hoped for answer. Am I wrong in? Because it sets out the three questions.
It gives that impression. Yeah, we're not going to quarrel with that.
I'm not pushing in any direction. I'm just trying to work out what these documents are. I have no view one way or the other. But on a first reading, I wondered whether it was the actual answer given by the mayor, but it was undated. And now having looked at it in comparison to 156, that appears to be not the case.
Well, the only point I would make is if you go back to the email from Mr. Sikora, it does refer to a telephone call that had taken place between the mayor and Mr. Sikora. So it is possible that the draft reflected that conversation. Now, I'm simply speculating there. I don't know. We may have to explore that with the mayor.
Thank you.
Position. Seems to me that the position is relatively clear and we can move on.
Thank you.
Who was giving instructions to Mr. Sikora at that time on behalf of the company?
Me, I was.
Okay, thank you.
Could we pull up Mr. Fraser's witness statement at paragraph 55?
First witness.
Yes. Let me know when you've had a chance to finish reading 55.
Okay.
Mr. Fraser, this was not the only report that you had concerning the events of the time frame you're describing here in 55, correct? That this was not the only report you had.
I received reports from a number of people.
All right. Now, if you'll bear with me a moment, Madam President. I'd like you to look now at 161, C161. And Mr. Fraser, I'd like you to bear in mind that I'm only talking about what's in the record, all right? So it's way too late to be introducing matters not in the record. So I want to focus on what's in the record, okay? Now, this is a report from the attorney for both AOG and Sesti Snoma, correct?
Correct.
And it, by its label, purports to be a report of the 3 days, 16th through the 18th. Would you agree?
I would agree.
But as I read it, it appears that Mr. Vardestock from the Slamka firm was present only on the 17th and the 18th. But was there for what appears to be 11 hours each day. Do you agree?
Well, 11 hours on the 17th, certainly.
And then
Correct.
on the 18th between 8 and 7.
Right.
Right, so 11 hours each day. And did you ask him to make this report to you?
I did.
And what was your reason for requesting this report?
I specifically wanted a record of the intervention of the prosecutor.
And there was, however, additional information provided by Mr. Vardestak, correct? AOG's attorney.
You mean in that statement?
Yes.
Yes.
He reviewed the events that he observed that were significant to him. Is that fair?
I think that's fair. Yes.
It includes reports of protester activity and location of that activity.
Could I see the second page, please?
Certainly.
Yes, I agree.
And he discusses the arguments that he purports to have made to the prosecutor. Do you see that?
I see that.
And the location of the police in various activities.
Yes.
There is no mention of anything to do with the Crow incident, is there, sir?
No, there is not.
And are you aware of any other documents in this record that describe anything concerning the Crow incident from anybody else there? Just, is it in the record?
And the Crow incident being,
What you described in paragraph 55 of your witness statement.
him being struck. You're saying this, sorry, the question is,
Are there any other documents in the record that relate to this other than the report of Mr. Vargastak?
I believe there may be a photograph or two.
And those are the photographs we've seen of Mr. Crow in the wheelchair and Mr. Crow standing near the automobile.
That's correct.
And that's all you're aware of? Documents in the record
When you say the record, you mean
of this
of
proceeding?
these proceedings? That's all that I'm aware of, yes.
Excuse me. I believe you were in the room during the opening
Mm,
statements,
Hmm.
and so you saw part of a video that was
Correct.
presented to you. You're aware of the video.
yes.
That's I consider that a document
Hmm.
in the record. Perhaps I misunderstood.
We do too. I appreciate the clarification.
Thank you.
Yeah.
Thank you.
Mr. Fraser, I'd like you to turn to C-340. Let me know when you've had a moment to review this. This was a meeting you had requested, is that right?
Yes, I think that's right.
You attended this meeting.
I attended it, yeah.
Was the discussion in Slovak?
It was in Slovak, yes.
And did you, I assume, did not have a contemporaneous translator with you?
I think I did have a contemporaneous translator.
A colleague?
I don't recall. It could have been a colleague or it could have been a professional interpreter.
All right. But do you believe this is a fair and accurate statement of the conversation as translated to you?
Yes, I agree.
And this, of course, was an email to the CEO, and you drafted the email.
Correct.
Now, calling your attention, your purpose in going to this meeting was to seek agreement that there could be a special purpose road involved in Smilno, correct?
That's correct. Essentially, yes.
And he was unwilling to agree with that suggestion, correct?
That's correct.
And you wrote, "We threatened them with litigation." Were you the speaker on that?
I might have been. I don't recall.
Don't recall. Was that something that you had pre-cleared with Mr. Lewis, that if things didn't go well, you would threaten them with litigation?
I'm sure that I had his authority. I mean, I put it there to mention the possibility of litigation. Obviously, it wouldn't have been couched in that language in a conversation with the police officers, but we may well have mentioned the possibility of litigation. I think we had at least one lawyer present with us, if not two.
But it was clear and unambiguous that you threatened Mr. Shabara with litigation, correct? There was no doubt about that in your mind.
I think we indicated that we could take them to court, yes.
Well, the words you chose to Mr. Lewis, the CEO, to express what happened at the meeting, you said, "We threatened them with litigation." That's what happened, isn't it?
Well, you don't always use the same language
I-
across the table as you do in an internal communication.
I understand, but you don't have any memory of what language was spoken across the table in Slovak.
I do not.
You're
no.
essentially speculating on that point, aren't you?
I'm not speculating, no. I mean, I was being, I was aware of the content of the discussion.
Now, in the next paragraph, you wrote, "We have decided to try and fence the whole track if possible." The whole track meaning the access road.
That's correct. That's what that refers to, yes.
And if that's not possible, you wrote, "We will put a gate across the entrance to the track," correct?
That's what I say there, yes.
And that work would start tomorrow and on fencing the track next week. That suggests there already were contractors who had been engaged to do the work.
Well, there were contractors engaged to come and fence the location. So I think the thought there was that after they'd finished fencing the location, they would then be instructed to fence the track. As it
All right.
happens, we didn't fence the track. It was an idea and it was dropped.
Whose idea was it?
I expect that it came about in discussions with someone in our legal team, and probably including the farm as well, who the main interested party. But I think we probably then revisited it with the farm, and it was dropped as a result of that.
But there's no indication of that in this document, is there?
No.
Is there any other email that would corroborate what you're saying now that you're aware of?
There are other emails referring to to contacts with the farm, but I don't think there's any emails referring to the farm, for example, discussing this with us.
Or the plan, as you just described, to drop the fencing idea?
Well, that is the only reference, as far as I'm aware, to the fencing idea, and we dropped it I believe, the next day.
And excuse me, who was involved in the decision to drop it?
I think that we just had a meeting with with a number of police officers, with two of our legal advisors present, and we had felt that we felt that at some point we felt that they would agree with us on the special purpose road issue. We were very frustrated that that had not happened. And in the discussion afterwards, I think the suggestion came up, well, could we look at fencing the road? Has anyone thought about that? And there would have been some kind of conversation with the farm to see what their reaction was. And then it was dropped. It never pursued after that.
Thank you.
You agree it would have been fairly difficult to to fence the entire track and maintain a position that it was a public road. You'd agree with that, wouldn't you, sir?
That could have been one of the reasons why we dropped it. I don't recall.
Now, the very last line, how are you getting on with Ackard? That's a reference to the funder that we discussed earlier. And by this time, the picture was quite grim there, was it not?
I think that they may have been, I don't recall when they got behind on their payments, but it was perhaps around this time. I don't recall now.
Well, they certainly had already received the notice of default by this point.
No, they had not. That came in December, late December.
Pull up R142, please. Now, there are a number of questions I have for you on this document, Mr. Fraser. This is labeled in the regarding line as a notice of default, correct?
Yes.
And it's a lengthy letter written by Mr. Lewis and sent to the principals of Ackard and one of the funders who apparently was part of the Ackard group. Is that your understanding?
Yes.
And this is the first time that Mr. Lewis had put them on formal notice, agreed, of default.
Yes, I agree.
But there had been a number of discussions as a run-up to this notice, which had raised significant concerns about the status of their ability to continue to fund. You agree?
I think that I believe that's right. Yes.
Now, Mr. Lewis was reporting here that in the second paragraph, we believe that all of the efforts in 2016 have paved the way for operations to recommence in January, February 2017. And then Mr. Lewis went on to note that his funding arrangement was exclusive with Ackard. Do you recall that discussion?
Yes.
One of the real challenges that AOG was facing at this time was that it had an exclusive relationship with Ackard and could not seek external funding elsewhere, correct?
We were committed to working with Ackard exclusively.
And Ackard was in arrears on its funding obligations to the tune of almost $190,000, according to Mr. Lewis's letter.
That's correct.
And that arrearage related to cash calls that had been made for the period, if you look at page 5 of 5, for the period from 23 October to 29 October. Mr. Lewis was essentially providing a running balance of the defaulted amounts that were overdue. Agreed?
Yes, I agree.
And as the CFO, had you helped him prepare this table of arrearages?
Yes, I would have done.
Did you draft the letter,
No.
Mr.?
Well, sorry, I don't recall, to be precise, but it may have been a joint effort. I don't recall who took the lead on it.
But did you understand Mr. Lewis's sentence at the beginning of paragraph 2? We believe that all the efforts in 2016 have paved the way to suggest that it was the capital challenges that AOG was then facing because of these arrearages that were causing the delay.
No, they were withholding money because they were concerned about the delays in our operations.
But when we review the exchange of documents, such a statement is not present in any of the documents, is it?
Could we go back to the first page, please?
I may have misunderstood your answer, Mr. Fraser. So your point is that there may have been delays in the operations,
Correct.
period. Yeah, okay. So now let's look at the status of the funding at that point in time. What was their total commitment at that point in time?
Just under, they committed under the agreement, just under $4 million.
And at that point in time, at the top of page 2, they have advanced approximately 1.95 million. Correct?
That's correct.
And at that time, you had to defer salary, correct?
Yes,
And Mr. Lewis reports that he had as well, 90,000 and 210,000 respectively, for a total of 300,000, correct?
that's correct.
Had Mr. Bonata's salary also been deferred?
No,
So you were the only two.
correct.
And the second paragraph also notes that a number of Alpine invoices had remained unpaid. Was that your understanding?
Yes, that must be correct.
And the original understanding with Ackard had been that there would be a formal second stage agreement. You remember that?
Yes, I do.
I may be wrong, but I've understood it that there was sort of a letter of intent in the original stages of the deal, but it was contemplated that there would be a formal funding arrangement.
Well, there was something called an initial funding agreement, which was intended to be replaced by a more substantial document, and that didn't happen.
That never happened.
Correct.
And despite repeated efforts on AOG's part, both you and Mr. Lewis, they never were in a position or apparently willing to proceed to that next step of formalizing the agreement, correct?
I don't recall why they delayed, or why that side was delayed, but I do recall that the delays in our operations was a factor for them.
Mhm. And that reluctance to complete the formal agreement that had been contemplated had led to some significant tension in the relationship, correct?
I think that's right, yes.
He had noted there had been disagreements and confusion as to responsibilities. That's in the bottom of the third paragraph. And that as a result, the relationship had been severely strained. Is that consistent with your recollection?
I'm sorry, which page you on?
I'm on page 2, third paragraph, under the section formalizing the agreement.
Yes, I would agree.
Now, at the, on page 3, Mr. Lewis wrote that as communicated regularly throughout 2016, Alpine experienced significant operational delays in Slovakia due to protester activities and their legal challenges. See that?
Yes,
Had you told Ackard that the protesters had been successful in their legal challenges?
I'm sure they would have had a good understanding of the overall picture, so they would have known about the injunction, I expect.
But I think I need to understand why you're sure. Because did you forward to them the detail on the various court actions that had been proceeding in 2016 and early 2017?
Well, here we're in talking about late 16 or mid 16. When I mean, Mike had the relationship with Ackard, so he maintained most of the dialogue with them. I supplied some financial information. But I was involved in some conversations with them, and to the best of my knowledge, they were well aware of all the issues we were facing.
Do you think they were well aware that throughout 2016, you were conducting operations without compliance with an injunction?
I think they would have been aware of the existence of the injunction, and they would have been aware that we were looking to find means of drilling on that location
Despite the injunction.
without being caught by the injunction.
Mhm. Now, the particularly challenging news at a meeting on December 1 was Ackard's disclosure that Ackard CVP had not invested any of its own funds. Were you aware of that before that disclosure to you?
Could you show me that in the letter, please?
Yes, I'm sorry. It's right underneath the December 2016 proposals.
We were aware that Ackard was a consortium of investors. So I think we assumed that they would procure funds to invest, and that they might not necessarily come from Accard LLC, but they might come from co-investors.
But you were not, prior to this December 1 meeting that's being described here, you were not aware at that point that all the investments were from third parties and that these third parties were done.
I believe that Mike can, sorry, I think that Mike was closer to Accard than I was, so he will have had a better understanding of the dialogue with them. But I think we simply regard them as an investor with a co-investor, and we didn't differentiate between funds that came from them or from a co-investor brought in alongside.
But what the news was here was there wasn't going to be any more funding from Accard.
That's correct, and that was due to the delays in operations.
And they had forwarded earlier in December, I assume, correct me if I'm wrong, but there was in response to some earlier negotiations, there was a partial payment against the arrearage on the cash calls of $25,000. You recall that? This is at the bottom of page 3.
Yes, I recall that.
But that shortly after wiring the money, they made demand to return it. They being Accard.
That's correct.
And despite the fact that AOG, if you'll go to the top of page 4, was, and I quote, extremely short on funds because of Accard's CVP's failure to meet cash calls, DG, Discovery Group, once again accommodated Accard and agreed to refund the money. Correct?
Yes.
And at that time, Discovery Group reported that it had only 10,000 available to refund. So noted that the balance of 14,800 and miscellaneous dollars would need to be deferred. And there was no response from Accard, correct?
They responded to this notice, yes.
Yes, they certainly did, but I mean, they hadn't responded to his proposal on refunding only a portion of the money.
I believe they demanded the payment of the balance.
And given the challenges that the cash shortfall had created at the time, Discovery actually made a proposal to Accard to acquire AOG, correct?
Require Alpine. Yes, that's correct.
But Accard didn't respond to that proposal either.
Correct.
So in the next paragraph, Mr. Lewis goes on to report that Discovery Group was in a critical position. Correct?
Yes.
And as CFO, did you share the view that Discovery was in a critical position?
We were short of funds, yes, at that point.
Right. But my specific question is, did you agree with Mr. Lewis that the position had become critical?
Yes, I do, yeah.
And that was made critical by the fact that under the notice of default section in the second paragraph, Discovery noted that it has no alternative sources of capital in place, correct?
We didn't do that. That's correct. We had no other investors lined up.
And then he concludes in the final paragraph, beginning on that page, that it has no other alternatives other than to send the notice of default, making specific demand for the payments. And then in the final paragraph, after the table that you indicate you helped prepare, he wrote, if Discovery finds itself obliged to enforce a default against ACARD, it intends to immediately seek alternative sources of funding with a view to ensuring the continuation of its operations. But then he writes, although it is not legally obliged to do so, Discovery will also seek to ensure, but without legal obligation on its part, that ACARD ultimately receives the return of its 1.95 million investment. Is that right?
That's what it says, yes.
And it was prepared to return the money, notwithstanding ACARD's persistent default on funding its obligations, correct? That's what it said.
That's correct. I think that Mike was keen to avoid a big legal battle at that point with ACARD.
And it's clear that a potential legal battle was brewing, correct?
If we had, it could have been brewing. I don't know. We obviously resolved the situation with ACARD, reached a compromise, but Mike was happy to offer to make them whole if and when he was in funds to do so.
And if we step back from the minutia for a second, ACARD is delinquent on funding. No other alternative sources are available. He's not prepared to invest anymore. And he's offering out of the gate to return their funds. Correct?
He's offering to return them if and when you like.
If and when. And the reason he's doing that is because he wanted to avoid litigation. What claims had they threatened at that point in time?
I don't believe they threatened any claims. They did reply to their notice of default. But I don't think they had not threatened any claims.
Well, that reply is at R143. We'll take a moment to look at that right now. And I'm going to wrap up after that, Madam President, just to keep you posted on where it is.
Everybody's hungry, yes.
I know it. I am too. I apologize for going over here a bit. I'm not going to take the time because we're all hungry to read through this in any detail. The document is clear on its face, but the one point I did want to note is the suggestion over on page 2, whether DG had made certain representations. It was a strong response that there had been no default, and in fact, it was AOG that was in default. That was the gist of it, correct?
No, I think that's correct, yes.
Right. And there was a suggestion that whether DG Alpine has complied fully with all laws and regulations, including the Foreign Corrupt Practices Act, needed to be investigated further. You see that?
I see, yep.
And after this exchange of letters, the net result was a settlement agreement. They were released fully from all funding obligations. Discovery was released from all claims, including those that had been threatened in this letter. And it agreed to refund almost $2 million, everything they put into it, if and when AOG had the ability to do so. Correct?
That's correct. There was no firm agreement to refund, but it was, yeah. If I have the funds, in fact, in the previous letter, he says without legal obligation.
And we have a moment, Madam Chairman. Is it true, Mr. Fraser, that after this release of ACARD from funding obligations, AOG never obtained any additional external financing?
Not from any third-party investors, that's correct.
And Mr. Lewis made it clear, both to you and to the other JV partners, that he was not going to be contributing any further funds, correct?
That's correct.
Including even payments towards the license. Is that correct?
He may have, I forget what he actually said, but he did make some more payments into the company towards licenses, for example.
And then on 3 October 2017, that would be C-382. If we could turn to page 3 at the bottom of that page. This begins a discussion of the withdrawal of one or all parties. It reports a discussion of that. And I note that Mr. Lewis was himself the secretary of the meeting. Does that mean he kept these minutes?
He would have kept them, if that's what it says, he kept the minutes, yeah.
Yes, it says that under item 1B on the first page, Michael Lewis agreed to be the secretary for the meeting. So back to page 3. Under the heading legal and financial consequences relative to the joint operating agreement. And then under the Slovak law section, you see that?
Yes,
You are reported to have said in the last sentence of that section, Alex said that he feels that it could be a long process, but that he felt we will ultimately prevail. Was that an accurate record of what you had said at that meeting?
I expect it was, if it's in the minutes, yes.
And then when I read Mr. Lewis's report, he sounded decidedly more pessimistic. Do you agree?
Yes,
Is that, and he wrote that AOG doesn't have the funding in place to continue to battle or for arbitration, suggesting that Alpine doesn't have the horsepower or appetite for it. Alpine suggests that it would like to reduce to a 5% interest in the project. and stay involved to the extent desired by the partners. That's over on page 4. And then he noted in conclusion, Alpine was going to need to seek additional funding, keep the partners informed. But Alpine didn't feel that it would be able to pay its share of the license fee. Is that consistent with your recollection of Mr. Lewis's assessment of the situation?
Yeah, I mean, yes, because it was dependent on Mike Lewis for support at that point.
Because it was dependent on Mike Lewis's,
Well, the only source of funding,
was Mike Lewis.
Yeah.
And without any external financing and without Mike Lewis's financing, it was game over at that point, correct?
we carried on for a period of time, but we struggled to raise any external finance. So at that point, it was game over.
Thank you, Mr. Fraser. Madam President, that concludes my cross-examination.
Thank you. So I suggest we take the lunch break now, and then move on to redirect examination and tribunal questions. Mr. Fraser, during the lunch, you continue to be sequestered, so I'm sure the claimants will arrange for you to have lunch somewhere, but on your own, unfortunately. Should we be back at, well, what do you want, 2:15, 2:30?
Yes, Madam President. That's
Yes, but this was an alternative.
Perfect. Red wine, red or white wine?
I was distracted. I apologize.
Could we say 2:20?
We can say that, yes, absolutely. So 2:20.
2:20. Thank you. Thank you, Mr. Fraser.
Yes, sir. I hope everybody had a good lunch and you too. Mr. Toshingham.
Thank you, Madam
it's
President.
Your turn.
Thank you. I just have a few short questions by way of re-examination, Mr. Fraser. Do you recall that Mr. Alexander asked you some questions early on in your testimony about whether you understood that the road was a public road?
Yes.
And you referred to an internal report about a conversation with the mayor in June or July of 2015. Do you recall that?
I do.
And you were asked whether you knew whether that report was in the record.
Yes.
Could I show you, and your answer was, I don't know. Could I show you, or could you please be shown document C-281? And do you see that this is an email from Mr. Lewis dated the 5th of August, 2015, in which you are copied?
Yes.
Could you please turn to page number 2? And do you see the section, the sentences beginning Smilno location and then the following paragraph? Could you just read that to yourself?
Yes.
Was that the internal report that you were referring to in your?
Yes, that's correct.
I have no further questions to ask by way of re-examination, so I'm now in the tribunal's hands.
Thank you. This refers to the actual drilling site, or does it include the road?
It refers to both. The third last paragraph says Smilno location, and that's the discussion of the well
And then it
location.
goes on.
Correct. And then the next paragraph, access road is a public road.
Thank you. No further questions.
No further questions.
Do my colleagues have questions? Yes, please.
Shall I begin?
Yes. please.
In no particular order.
Microphone.
Okay, thank you. Excuse me. In no particular order, but I will start now on a related point, if I may. I didn't know that you were going to take us here, Mr. Tushingham, but I'm glad you did. At paragraph 9 of your second witness statement, sir, could I ask you to pull it up for the witness? I'm sorry, I don't know the gentleman's name. Thank you. Let me see. Let me go there now. Yes. I'll ask you just to read the paragraph to yourself for a moment, sir. You don't need to read it out loud.
Okay, yeah.
Thank you. You reference a meeting on site. You mentioned 2 agreements. It was agreed that there was no issue about using the road. And it was also agreed that the road needed to be adjusted to reflect certain coordinates. And at the end, you say a minute of the meeting was signed by all parties. You refer us to exhibit C280. Could I ask that be shown? Thank you. Is that up? It is up on the screen. Is this the minute you're referring to? And let me ask a more fulsome question so that you understand. I don't see, I suggest you, well, no, I'm not suggesting you, I'm telling you, I don't see reference to agreement on either of those points in there. I don't know if it's, maybe you'll tell me, well, you read it otherwise.
I agree with you. I think what we recorded it was, it says there a minute of the agreement. It doesn't, it's not actually the agreement itself. And my understanding is it was a verbal agreement. And this is just a note of the points, but it doesn't say agreed. I agree with you.
Okay. And just to be clear, counsel, I've looked, I can't do more at the Slovak version. I don't read Slovak. It doesn't appear to say any more than this, but if I'm wrong, please correct me and correct the record.
Mr. Driver, do you see in this document C2?
Yes.
280, it refers to location of the access road on parcel type C, serial number 945, unrecorded ownership sheet, built up area road.
Yes.
If it assists you to look at the title deed of that parcel, that is at C-139, and that may explain what these minutes are about. So do you see in this document?
All right, so I was going to say, you're welcome to argue that in due course, but now that it's up, I'll look at it, sure. I'm still, sorry, you're ahead of me and I'm slow to catch up. Are you suggesting that this helps me find reference to these 2 agreements?
No,
in the minute?
Maybe we can deal with this in due course. It was just to help you with your effort to understand what was being referred to in these minutes. And my only
I understand, refers to this.
Exactly.
Well, this is the reference to correcting the coordinates in the cadastral register, I imagine.
Sorry, the document on the screen, C-139.
Yes.
No, this is the, as I understand it, an extract from the land registry in respect of plot number C and the way of using the plot number 22. That is where it says land on which an engineering structure is built, road, local and special purpose road. And that is the parcel that's referred to in these minutes at C-280.
I see. All right. Well, I'm going to leave it there. Well, unless the witness has something he'd like to add. No. All right. And you know what? And I'll look forward to further explanations in due course. Thanks. A couple of other questions, if I may. Paragraph 42 of your second witness statement. This is a discussion regarding financing and Romgas's conduct and JKX's notice of its intention to withdraw. The notice from JKX is, help me with the exhibit number, 185. Could I ask that that be pulled up, please? I've got to. Could you scroll down to the last paragraph of the JKX email? Right there it is. Yes. The last, you may or may not know the answer to this question, because I'm going to ask you what the sender meant. But the last second to last paragraph, first sentence reads, for your information, the JKX Hungary assets are also up for sale. Now I look at that and it suggests to me that JKX might have been exiting a number of its investments for reasons wholly unrelated to any act or conduct by the Republic of Slovakia, or in fact, any facts related to Slovakia. They had their own reasons to divest. How does that, what do these words mean to you? Why would he be telling you that he's exiting Hungary as well as Slovakia?
I would think, just in the interest of openness, that he would mention that, I think. We had a very good relationship with JKX. It was very, very open relationship. So I expect it was just being complete.
Okay, thank you. If I could ask you please to turn to your first witness statement, paragraph 99. I hope I've got that right. I'll tell you in 1 second. Yes. Yes. Paragraph 99. On the second page, at page 36. There's a sentence. Well, so 1, 2, second line. Mr. Harakal told us unofficially that the outcome of the process had already been decided by his superiors in Bratislava. He did not say what the outcome would be, nor did we ask. And I have a question mark next to nor did we ask. Why wouldn't you have asked? Why didn't you ask?
In hindsight, it would have been a good thing to ask. At the time, it was a meeting in Slovak where I was an observer rather than a participant. And I didn't really feel I could I didn't really want to be the foreigner butting in on the conversation between a Slovak official and our Slovak colleagues, but it would have been a good idea to ask if I would accept that.
Thank you. It's true. I forgot actually your testimony earlier that these meetings were taking place in Slovak and you were hearing part of it live, but probably not all of it live. At the very outset of Mr. Alexander's examination this morning, he asked you several questions about your role with Discovery and Alpine, with the companies, if you will. And you described how your role evolved a bit over time. And that reminded me of points that had occurred to me as I was reading your witness statements before listening to you and meeting you today. Which is that it seems to me, please correct me if this is if this is wrong, but it seems to me that your role evolved eventually so as to encompass virtually every facet of this project, from the legal to the financial, technical, operational. Beyond, if you will, the sort of limited description that Mr. Alexander suggested to you this morning. Is that a correct impression that I would have had? You seem almost to have been the chief operating, well, forget the titles, the operating mind of the project on the ground.
I would say I would more or less agree with that, save for technical. I
Okay.
didn't really have any input on the technical side, but certainly finance, legal, and PR. I got involved in the PR. as
PR,
we
the
went
political
forward.
side, exactly.
Yeah, all those aspects.
And I recall from your witness statements, your description of your previous activities.
Mm.
So what I want to ask is this, however you would characterize it, this expanded role with Discovery in this project, was it something you had experienced in past employment opportunities or in past projects?
Not exactly, but I would say there's something similar in a sense, in that my previous company where we were exploring in Poland, we were
Yes.
again a very small operation.
Yes.
I actually had a colleague who was in charge of legal affairs, but I did have in the distant past some legal experience. So there I was involved as chief financial officer, but had some input on the legal side and a little bit on the PR side, just because we were a small team.
I understand. And I think you've put your finger on, at least from a definitional standpoint, which doesn't mean much. This is a big role for a CFO, if you will.
Yeah.
In a traditional description of one's functions.
Yeah.
I believe, Madam President and sir, that those are my questions. Thank you very much.
Hello, thank you very much for being with us. And just following on actually from Mr. Dreimer's last question, I mean, just against the background of the conversations we've been having over the course of today and this dispute at this single site, the Smilna site, just stepping back now with the passage of time, would you say it's a fair characterization that the heart of this dispute was one concerning the use of a plot of land and competing views as to who had rights over that plot of land, characterization of the thing called a track or a road or whatever it may be? I mean, how would you characterize the heart of the issue on this particular side?
It's true we had competing views about the nature of the plot of land. I mean, actually, I think I would probably, to a small degree, because I think to all intents and purposes, in our perception, this road was used as a road. The only entity that's ever been stopped from using it was Alpine Oil and Gas. So as far as we could see, it was a road, it was a right of way. And so I don't feel that others saw it as anything different than a road. Our view was that the dressing it up as a piece of private agricultural land was a convenient legal fiction, and it didn't reflect the realities. So I would say that it was more about whether it was more about for us, a very small group of individuals stopping people coming in and doing something different, if you like, in the area.
That view, and I'm being very careful not to express a view as to what this thing was. And, I mean, that's you've articulated the view from your perspective as CFO of Discovery, but of course others held a different view. And it wasn't just a few individuals, it was also apparently the local police, more than one Slovak court. Against that background, did it not give you pause for thought as to whether the characterization that you've put on that space is the correct one? I mean, you seem to be saying, if I've understood you correctly, that all those other folks just got it wrong in their characterization. Is that your position?
I would say that we got mixed signals from the police. Sometimes they said, remove the car. Sometimes they didn't. So far as the courts were concerned, it's true that we met a brick wall with the injunction and the refusal of the injunction. I think for us, what defined the environment a lot was the PR aspect, and I would say that the people who were opposed to us were very effective communicators, very good, and I have to acknowledge that. And they were very good at creating an atmosphere. I mean, we became famous in Slovakia, actually. We could go to a meeting in Bratislava in the ministries and say, oh, we've heard all about you. Don't worry, you're famous. You know, you're on the national news. We're a small company in a distant part of Slovakia, and yet we were very famous because these activists would go and, you know, they would lobby in Bratislava. They would disrupt ministerial meetings. Their Facebook posts were aggressive, both against us and against the government. So for us, it was, I think we did wonder if the position of the courts was also affected by the atmosphere, by the public atmosphere. And the police, yeah, I mean, my impression was that there were policemen we could speak to who said, of course it's a road, but the ones that counted, they were not prepared to take that view.
And you mentioned the courts. I mean, what was your reaction to the decisions of the two court decisions in relation to the injunction?
We were appalled. You know, we thought it's absolutely ridiculous that an asset which is worth 100 euros, we paid 100 euros, I'm sure much more than anyone locally would have paid for 1/700th share in that road. They wouldn't have probably paid 10 euros. That asset could be protected by an interim injunction, to us was absolutely a perversion of justice. It was very, very oppressive, we considered. And we were very surprised that it wasn't reversed on appeal. So yes, we found, and then it was impressive. It took a month to obtain that injunction, a month to hear an appeal on it, which was rejected, and then we applied to, because the only way we could see of getting ourselves out of this injunction mess was to concede the claim. It took 4 months to close that claim, for that judgment to be issued on that, and it took another, whatever, 6 months after that before the injunction was finally lifted. So it felt like the system was rigged against us.
I understand that's your perspective. I mean, you've got a legal background, so you have some knowledge of how these things are done. One of the things that is quite striking for me is that when you were discussing earlier the preparation of a report on the status of the road and so on and so forth, there doesn't appear to have been, prior to your acquisition, a detailed due diligence on exactly these kinds of issues. I mean, one knows, you know, I live in a small village in France, and every time you've got to do some activity, you need some sort of permissions, and the amount of time you spend on finding out in advance and getting legal advice on what you can do and what you can't do. And yet here you're talking about a significant investment, and yet there doesn't appear to have been, and we heard from your counsel, in effect a confirmation, a really detailed due diligence in relation to these kinds of issues of ownership, of access, of rights in advance of investing and of getting involved really actively in the project. And I'm just wondering whether you might observe whether that's a fair characterization, and whether now, with the benefit of hindsight, you might not have taken steps earlier to
Mm.
inform yourselves on the regulatory and legal situation in Slovakia?
Mike and I had worked together in Poland, where we drilled a number of wells there. Ron Crowe had also worked in Poland and Hungary. We took comfort also from Stanislav Bernarda's experience. He was, a veteran of the Czechoslovak oil industry. We didn't, there is some oil and gas activity across the Czech Republic and Slovakia, not a lot, but there is some. And we weren't aware of any of these kinds of issues being problematic. We perceived it as an investor-friendly country, like Poland, for example. That's true. The Polish oil and gas sector is much larger, but the land ownership issues are pretty similar. So, I mean, I think a small company is probably not going to invest a lot of money in legal due diligence before an acquisition into these sorts of issues. I would say, and when it got near at the time of actually looking at specific locations, we did all that was required in terms of leasing the location itself, for example, for which we use lawyers. The road at Smilno, I think we relied on the statements we had from the mayor and the farm.
Okay, thank you very much.
Just following up on your role, we've already discussed the fact that your role was beyond the responsibilities of a CFO, as it is usually understood in a company. And it encompassed a lot that I would have thought was within the CEO's attributions. And I was wondering how the tasks were apportioned between yourself and Mr. Lewis.
I would say that Mike Lewis was very much in charge. It was his company, and to the extent that I got involved in, for example, meetings with government officials, that would be in consultation with him. It might be because he was in another country at the time. But any important meeting, I mean, meeting with the minister, Mike would come over. I saw myself as supporting him in areas like public government relations or public relations. I managed a lot of it myself, reporting back to him. But government relations was at the end of the day his responsibility, and I would support him.
In your witness statement is the first one, in paragraph 92 on page 32, 33. If someone could pull this up. You say that early 2017, you started engaging with the activists. And actually, it was quite a productive engagement, if I understand well. Why did you not do this earlier? Did it occur to you later that maybe it would have been a better approach to engage with them rather than have these confrontations?
There actually had been quite a lot of engagement with activists from the outset, but it's just that it went into on a more serious level, if you like, at this stage. But
just to be clear, I understood you before to say you are making a distinction between the activists and the local residents of the village.
Yes, very much so, yes.
So where do you classify Mrs. Varyanova, for instance?
So we would say she's a resident of Smilno, but she's one of the small group of activists. There were probably a couple at each location, roughly.
And these activists, what do they, usually, at least the way I understand it, is activists promote a cause, right? Like protection of the environment, of human rights, whatever. What was their fight about?
essentially it was for them, it would be put on an environmental level. It was that you're going to harm the environment, and there was really almost nothing we could say that we found that could make them comfortable on that. I would say that just going back, if I may, to your previous question.
Yes.
Stanislav Bernarda had discussions with Vilk, which is the sort of organization behind them, from early 15 onwards, or even 2014. There was quite a bit of there were various conversations between Mrs. Varianova and AOG representatives, including Stanislav, Mike Lewis in December 2015. We knew quite a few of these people a bit, and they were always very hostile to us. And Mrs. Varianova was very hostile to us. So we felt we would have liked to engage with them, but we felt that it was always used against us.
So why did it change in 2017?
I suppose a slightly different approach, which was that we had someone who had been helping us since the beginning of 2016, who was very local, quite well connected locally, who was, I would describe him as a local fixer, if you like, help set things up, set up meetings and so forth. And he knew one of the activists. I had known him for quite a long time. And when he started working for us, he said, do you want me to say anything to Mr. Furco? And we thought we had nothing to lose. And he was quite a smart chap. He was able to create the right conditions for a dialogue. I was a new face in terms of meeting the activists, so I could go along and slightly say, this is a new person, you can, say things to me, which you haven't said already, or, I'll give it a different hearing. So that helped. And I was very receptive to them. I went there with two colleagues, Peter being one, and another colleague, Igor Melish. I tried to, it was like, sort of trying to think like being on the psychiatrist's couch or something. You just want to let it all hang out. But at the end of the day, it didn't really change anything. It didn't actually remove the hostility.
Did it not change when you offered to do the preliminary EIAs?
I wouldn't say so, no. And we made a lot of propositions, concessions. We said before we submit the preliminary EIA application, we'll show it to you. You can comment on it. Say, ask us all the questions you want. We'll tell you about the drilling mud. They're very concerned that the drilling mud contained toxic chemicals, which it didn't. So we addressed all these issues, many of which would have been addressed in the past, but we did it again. But at the end of the day, when we filed these preliminary applications, okay, they objected to them, as Mrs. Baranov said in her witness statement. But the dialogue on other channels continued, the opposition through other channels. When we went to, I tried to get a new location next to Smilna, a place called Suriski Cherno, which is described in here. Again, the same activists were then lobbying people in Suriski Cherno to create opposition. Nothing had really changed. That was our perception, despite us making all the right noises and being as conciliatory and as accommodating as possible. It didn't make any difference.
And I have another question. You were here yesterday and you have seen the video of the incident with Ron Crow.
Yes.
It's on the record under R37.
Mm.
I didn't really understand what happened there.
Well,
I mean, it looked faked,
Mm.
frankly. I mean,
Mm.
at least that's what I see. But then what was the purpose of this seen? I mean, how did you understand this? Had you seen the video before?
I've seen the video before because it was in
Because it,
the respondents.
because it was in the record,
okay,
you had
correct.
not seen
I've not seen it
anything
before this
before.
publication.
But the incident had been reported to you at the
Yes.
time?
Yeah, and obviously Ron went to the local hospital and had his leg put in a cast, in a cast. What I heard at the time was that he had been not exactly what I've put in my witness
Yes.
statement. He was struck by a car, no damage, some bruising.
Yeah, but one doesn't put on a cast for bruising or.
Yeah, I mean, I have asked him again, and he said, well, I was in shock when it happened, and later on in the day, it got stiff, it stiffened up, and so that's when I went to the hospital. But, yeah.
Follow up, actually, if I
Yeah,
may.
sure.
No, just to follow up, just in response to the questions from the president, you come across as very balanced and very reasonable. I have to say that's positive. That's very positive. Just you don't display anger about the activists, as you call them, or local residents or property owners, however one characterizes them. I mean, in those circumstances, looking at that type of reaction from a local community, which for right or for wrong doesn't want oil exploration on the edges of its village, which seems to be what it's about. What is a state to do? I mean, that's an expression of a democratic society, the days where the state can just impose its will, or a company can come in and just say, this is what we're going to do. And you're obviously very experienced in that. You've been involved in this world. You know this is what happens. What is a state to do in those circumstances? Because effectively you've got stiff opposition. It may be a small number of people or a large number of people, but there's opposition. And in those circumstances, is it unreasonable what the outcome was in the face of such opposition? I mean, reasonable people may disagree on what's desirable or not, but actually, is it so problematic?
I mean, the opposition was as small as it was determined. That's the thing. It was very small, but they made up for that by their resourcefulness and being very, very committed. I know that there's a petition with 300 and something signatures on it. We question how all those signatures were arrived at, but that's probably a separate matter. We also know that our time in the village, we spent a lot of time in Smyrna. I mean, I lived there for a couple of weeks at a time in that hotel. My colleagues did as well. We knew a lot of people there. I mean, I would say, I don't think I met anyone who was opposed to us in the village apart from Mrs. Varianova and her brother. All the other people who came in, who were there, they were brought in from outside. When we tried to drill in, and you look at the photograph of the protesters, there's 23 of them out of a village of, of whom only a number of those, not all, a number are from Smyrna. Same thing when we were on the location in November, same number of protesters, half of them came in a coach in a minibus from a village called Pokostov, an hour away. This little group was able to disrupt operations wherever we went. So, is that representative of the community, or is that just, are they holding the community to ransom? I'm not sure which is the answer.
But I'm asking a slightly different question. I'm asking about the responsibility of the state, because these proceedings are not about the town, they're not about the individuals, it's about Slovakia. What is a state to do in those circumstances? I mean, you're familiar in the UK with similar situations in relation to coal mining in Cumbria, or the government's decision to issue new oil and gas licenses. There won't be millions on the streets, but there will be a number of people who will feel very strongly about it, who will make a lot of noise about it, and it will end up going to the courts, and the courts will end up taking decisions, and some people will like it, whatever they decide, and some people won't. I mean, that at a time in which the environment is of greater consciousness is an issue that all democratic states face.
Mm.
So is it your position that the state somehow behaved unreasonably in failing to allow you to proceed?
We think the state was captured in a sense by the small group, it was a coalition government, so the parties were slightly jockeying for influence between themselves. Probably no one wanted to. If you put your hand up on behalf of the foreign investor, you're going to be outflanked by somebody who's speaking up for the little Slovak guy. So it was much more convenient to support, the local Slovak. Call them community or activists, whatever.
You don't get to vote in Slovak elections.
Exactly, yeah. And that's what we feel happened at the Ministry of Agriculture and the Ministry of Environment. And we had a great relationship with the Ministry of Environment at a working level. Stanislav had known these ladies, Mrs. Macheva and Mrs. Yanov, he'd known them for more than 10 years. He would go in there a lot and we'd discuss a lot of issues with them. Same thing with mining authority or other authorities. It was easy to build a good relationship at a working level. And we felt that we were very welcome from the point of view of the operational people in the Ministry of Environment. The problems started when it went higher up and it became political, and that's where we were sacrificed to political considerations.
But aren't you describing something that happens in pretty much every country? I mean, you have observed, the debate on fracking in the United Kingdom. The investors who were behind that would have gone to various people and got the thumbs up and the green light, and it would have been authorized. And then it goes higher up and the authorization is overturned. Isn't that just the nature of modern democratic society?
I think to a degree, yes, but you still need to follow your own rules. And that's where we would say we were let down, is that they stopped following their own rules, or they interpreted them in a way that was prejudicial or biased or arbitrary. That's where that's our complaint, really, is that we were forced out by a misapplication of the rules.
Thank you very much.
Yes, you have an additional question?
I have
I may have one.
one follow-up and then a question that one follow-up, and then a question that I'd forgot to put to you earlier, if you'll indulge me. First of all, let me echo, I think you heard me say off mic, I too consider you forthright, calm witness, which is much appreciated. I understand exactly what you've just explained to Professor Sands regarding the sense of grievance, just to use that word, with respect to the political authorities at the state level. Do you say the same thing still with respect to the courts? In other words, do you believe the courts were prejudiced against you, discriminated against you, acted? I'm not putting legal meaning to any of these words. Do you think the courts were influenced by political considerations?
If I'm honestly speaking, I'm sorry.
Of course you are.
I'm always honestly
We
speaking.
take
Exactly.
that for granted here.
Sincerely, but the answer is yes, I do actually. I think that the prevailing political environment was sufficiently strong that that or some similar influence that it put pressure on the courts. I do feel that.
Okay, I'll leave it there. That was the question. That was a follow-up. Now, the question I forgot to ask you was this. And perhaps I missed something, and if you can tell me it's been answered, or counsel can correct me, so much the better. But you'll recall the long discussion with Mr. Alexander, which led to counsel agreeing to file the missing attachment to
Yes.
your lawyer's letter to you.
Yeah.
All right. That whole discussion was premised on the idea that you alluded to a written advice that you received from Mr. Sikora, right? It turns out, it seems, that the attachment to the letter was not such written advice to the company from Mr. Sikora. So I'd like to ask, do you recall whether or not you received written advice from Mr. Sikora on the question of the status of the road?
We received various bits of written advice from him, including on the on how best to go forward. One of which resulted in the Sestis-Milner approach. I believe we did also. I believe there will have been something covering the status of the road, but I can't specifically remember it now. But I believe there was.
Fine. And I gather then you, well, correct me if I'm wrong, you've just answered what my second question, which would have been, do you recall whether that advice is in the record? And I think you said you don't recall.
Well, I suspect it's not in the record. I suspect it would have been, sorry, in the for the arbitration.
Yes, excuse me, I mean that.
I imagine it will have been treated as privilege, but I'm not 100% sure.
Fair enough. Thank you. Those are my questions, Madam President.
Thank you. I think I have no further questions. This was a long examination, Mr. Fraser. Thank you very
Thanks
much
very
for
much.
your assistance.
Yes.
Should we take, what time is it? Not too long a break maybe, so we may have another one later. 10-minute break now, and then we hear Mr. Lewis.
That's fine by us. Thank you.
Resume. Can you please confirm to us, sir, that you're Michael Lewis?
I am.
You're President and CEO of Discover Global,
I am.
among other titles. You have provided us two written statements. The first one says 30 September 22 on the front page, but the signature says page says 30 December 22. Is that right?
Yes, ma'am.
Yes, it does. And the second statement says 15 September 23 on the first page, and it was signed on the 16th.
Yes, ma'am.
You heard as a witness, you're under the duty to tell us the truth. Can you please confirm, you should have on the table a witness declaration? Here it is, yes. Can you please read it into the record?
I solemnly declare that upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you. So we will first have questions from your counsel, and then we turn to the Slovak Republic's counsel.
Thank you, Madam President. Mr. Lewis, I understand that you wish to make one correction to paragraph 32 of your first witness statement. Could you please be shown that paragraph? The first witness statement of Mr. Lewis. No, I think that's the second witness statement. It's the first witness statement. Specifically, I think page 13. Para 32, yes. Mr. Lewis, could you please explain the correction you wish to make to this paragraph?
Yes, it's actually on the next page. The ending sentence, I would like to strike that, please.
So you would like to strike the sentence that begins, "This includes."
Yes, sir.
Do you have any other corrections you wish to make to either of your witness statements?
I don't.
Thank you. Could you please now answer any questions that Mr. Alexander will have for you?
Microphone.
My name is David Alexander. I'm going to be asking you questions on behalf of the Slovak Republic. Pleasure to meet you, sir.
Thank you, Sam.
Mr. Lewis, I read with interest about the early stages of your career in your witness statement. And I thought it was interesting that you would be describing some soft market conditions that you experienced early in your career. Tell me, sir, why you thought that was relevant to this proceeding. I don't disagree. I just curious what your view is.
The oil price does impact activities. In 1986, I was newly out of a boom and it hit me the hardest. And I think that that is something as a responsible oil person that you keep in mind all the time so that you're able to react and spend your money wisely.
And in that particular market, what sort of, do you have a rough memory of what the percentage drop in the market was?
The percentage drop was roughly not too dissimilar to what we experienced during this project. From about $100, I think, yeah, it made $100 down to, well, no, that's not true. I remember selling oil for $5.85 at one point in that particular bust. So that was much more extreme, but it's similar to this.
This decline was, I guess it peaked shortly after your purchase at about 107. Does that ring a bell?
I believe that's correct.
And dropped below 30.
It dropped below 30, correct?
Yeah. And could we pull up CE 41, please? Madam Chairman, this is a graph that was submitted by the claimants. It's one of those exhibits that might have some continuing relevance to questions as we move through. And with your permission, I'd like to hand the witness a copy of their exhibit, just so it'll be handy for him. And I won't put too much burden on the person having to operate the exhibits. Would it be helpful if I handed you one as well?
Yes, please.
You want one, Mark?
Yeah, thank you. On screen, great. Thank
Thank you.
Interestingly, as we look at C41, we can see that the dip lasted a long time and then the pandemic came along. With some improvement during a stretch in 18.
Yes,
Fair characterization.
yes.
Yeah, not very precise, but in the ballpark. In your early experience of a soft market, what happens to oil exploration during a decline that steep?
Well, first, I would not characterize this as a soft, or sorry, the prior event as a soft market. That was a devastating period of time when not only the oil business cratered, but the real estate business cratered and several other industries all cratered at the same time. So that is hardly a comparison to what happened to historically here, except in the oil business. But the response to, I'm sorry, could you repeat the question?
What happens to oil exploration when you get this kind of bottom fallout?
Obviously, in the one that we're referencing in 86, it was a terrible time. This one did not have those devastating effects. People continued to explore. The shale gas market slowed down dramatically because the costs there are so high. But the type of exploration we were doing here, so long as we could lower the cost substantially, which you typically can do in an environment like this, we had every expectation that we would be able to overcome this oil price and still make the project profitable, even if it took a while to rebound.
You, of course, testified in your own statement that you'd read Mr. Fraser's statement and thought that it was true and accurate. You recall that?
Yes, sir.
Look, if you would, well, I'll tell you what, in the interest of time, and I'm happy to pull it up if you'd find it necessary, but it's a short sentence I wanted to read to you. So you let me know if you'd like to have it pulled up.
Yes, sir.
He's talking about the decline in the 2014 to 15 in the beyond. He says, he describes the prices first, and then he says, against this backdrop from August 2014 onwards, it gradually became much more difficult to raise equity capital in the oil and gas sector as investor sentiment deteriorated. You agree with that?
It did deteriorate during that period of time, yes.
Right. And you agree it became much more difficult to raise equity capital?
As a general rule, yes, yes.
The reason I ask is you obviously have had a very successful career. Were a pioneer in fracking, as I understand it. And through that experience, put your name on the map in the United States, and then were invited to continue in Europe, correct?
Yes, sir.
And you had built up a remarkable network of contacts in the industry, including the investor network.
I had some contacts in the investor network. Most of my relationships were technical, though.
But in any event, in this market, after having purchased AOG in March of 2014, you went to work on raising external financing immediately. Fair?
Not really. I fully intended to investigate this project to determine what the upside of it actually was. As I entered the project, I had some basic understanding of the potential, some great enthusiasm about the area. But until I got in and really plugged in at the data, I thought it would be better to have someone alongside us to help defray the costs, lower the risk for me, if it was easy to do. And so we surfaced that to a few people. Alex in particular surfaced that to a few people to see if we could get someone to come alongside us, understanding that it was early days, that the work had not been done to really identify prospects to the point of being ready to drill, but that they would come alongside and help us develop this play.
You engaged some financial advisors, correct?
Yes.
And whom did you engage?
Jean-Michel was a friend of Alex's. I don't remember the name of his company, but we engaged with them.
Okay. And do you remember the deal essentially that was involved there? Claremont Energy, does that ring a bell?
Claremont, that's correct.
And I'm sorry, go ahead.
Well,
Well, that's all right. Let me
don't
just-
really, I'm sorry.
Let's put it in a point in time first. That agreement is R-123, if I could ask you to bring that up. You may want to take a moment and look at that.
Is there a way to make that bigger, please? The old eyes. Okay.
I get it.
Sorry, if I may just, please forgive me for interrupting, Mr. Lewis. There is also a screen to your right. You may
Yes,
not see
thank
that.
you.
Yeah.
That one's actually easier to see, so thank you.
So my first, and again, if you need more time to read, just let me know. I don't, it's not a race.
I'm fine so far.
All right,
Thank you.
good. This transaction with Claremont envisioned raising 15 to 30 million. Do you see that?
Yes, sir.
And that was for exploration projects in both Poland and Slovakia, correct?
Yes.
And how long was Claremont Energy in the picture for you?
I am not sure how we terminated that arrangement. But certainly for a year or so.
Mhm. And they brought some potential investors to the table for discussions.
Yes, that's my recollection.
And it is true that despite strong efforts, the investor sentiment remained in the tank and you got no takers, right?
Well, I wouldn't characterize this as an all-out effort. As again, we were looking for someone to come alongside us. It wasn't an investment in a well like many investors were used to. It was an unusual project requiring really someone that was in the business that wanted to participate in the development of the projects. So it was a difficult funding effort anyway. And then the fact that it was early days. So I wasn't surprised that it was difficult. It would have been wonderful to have someone come along with a big bag of money and fund, but I was perfectly willing to go ahead without it.
But you did make it clear to Mr. Fraser when he came on board, and this became part of his major work, didn't it? Trying to find financing?
It was part of it. I wouldn't characterize that as his major position, no.
He was CFO, but I understand he had a broad variety of other duties, but you asked him to, you made clear to him that you did not want to finance this by yourself.
I think I was pretty clear that I would prefer to have someone come alongside us and help fund the project. That's my recollection anyway.
Were you also at the time personally funding exploration in Poland?
I was.
And as events evolved, you continued to have some drain in the Poland ventures, which also impacted your capacity to invest in the Slovak ventures, correct?
Yes, the Polish activities did cost, but they were that the people, the office, the software, everything was also used for the Slovakia project. So it really wasn't that much of an extra cost to continue funding the Polish effort while doing the Slovakian one. And the geology is very similar. So the people that I had on board, I was doing a lot of training and trying to educate these guys. So it was good for them anyway.
So if you could turn to paragraph 34 of your witness statement. That's your first witness statement.
Okay.
And you'll see about 4 lines down the phrase, this sentence begins, my expectation. Could you can just read that to yourself.
Yes.
So the model you had in mind was that you would invest in the cost of the first 3 wells. And your business model anticipated that revenues generated from that would then become the funding source for any further drilling.
Well, this is the model that I typically had been using and continue to use, where I would fund the startup of a program, and then as it further developed, hopefully the project would then fund itself. So it's not unusual for me to think like that.
Would it be fair to say that in that model, early results can be pretty significant for the outcome of the project?
Of course they can, yes.
And if you had, well, let's go back to the question of your willingness to finance personally. What amount did you have in mind to finance for the first 3 wells?
If I recall, something like a couple million was my expectation.
And what were you estimating the per well cost to be for the first 3 wells?
Roughly $1 million to $1.2 million.
Now, in the
Excuse me, that's for 100%. Our net would have been 500 or so per well.
now back to the Claremont Energy, that's R123 again. You earlier noted that you were contemplating financing of 15 to 30 million. And you were contemplating how many wells in Poland and Slovakia?
I'm sorry, I don't recall. I think I read 3 a minute ago.
Yeah, in the first paragraph, under the proposed transaction, if we could highlight the first sentence. Again, you can read it to yourself, but in order to fund the development of up to 3 oil and gas exploration projects in Poland and Slovakia.
That sentence must not be the right one.
It's 3 lines down under proposed transaction, the right-hand side of the page is the part I'm calling attention
Up to
to.
3 oil and gas exploration projects. That is 3 projects. That would not be wells.
I see. And how many wells were you contemplating?
I don't remember. There were several in Poland and then several in Slovakia.
You had mentioned also in your witness statement that in your early activity in Poland, you'd gotten some very high estimates for the cost of drilling in the Carpathians. Do you recall that testimony?
I don't believe I mentioned any very high estimates in the Carpathians. Could you?
Maybe I've forgotten where it was. Where were your estimates from?
Northern Poland, I believe, is where I quoted.
You remember saying that they could be as high as, somebody quoted you a number, sort of a almost ridiculous number of as high as 50 million?
Yes, and that may sound ridiculous because we were so successful in getting it down, but there are, anyway, yes, I recall.
But as things developed in Slovakia, the costs you were having to incur personally substantially exceeded your initial ballpark for 2 million.
Well, unfortunately, we weren't drilling, so it was just overhead costs. I had anticipated that that would continue for some period of time until the drilling started, but obviously it extended for a much longer period.
Now, given the extension of time and the lack of progress you were making, did you ever reconsider the approach that you had in mind, which was to continue to look for external financing?
Reconsider for sure. As it became more difficult, the prospect of outside financing became more attractive.
Your interest in outside financing
Yes, sir.
became more attractive.
Yes, sir.
Right. Now, with Claremont, they were not able to bring anything ultimately to the table, correct? Actual funding.
I believe, yeah, that's correct.
Who did you go to next? Does the name Gulf Shores ring a bell?
I believe Gulf Shores came out of the Claremont relationship.
That's what it looked like to me, but it wasn't said quite explicitly. But that was all part of Claremont, but you also had a preliminary agreement of some sort with Gulf Shores.
Again, I'm pretty sure that came out of the Claremont introduction.
Mhm. Did Gulf Shores succeed in bringing anything to the table?
No, they didn't.
And when did you begin discussions with Ackard?
Sometime in 2015.
The agreement is dated 23 October 2015. Does that help at all?
Thank you. Yes, it does. It would have been shortly before that.
All right. And did you know the people involved with Ackard from your prior experience?
I did not, no.
How did they come to you?
I believe it was a friend at church. I'm not certain.
So could we bring up C-282, please? Take a moment and look at that, and you can ask for the next page whenever you're ready. I just want to give you a moment to have a look.
Okay. Okay.
What was the deal with Ackard?
That they would fund our operations for a few wells. I believe it was 3 or 2. And that we would ultimately put the Alpine asset in a NewCo, a new corporation that we would split 50-50.
And as I recall, there was a series of steps in the financing depending upon how things went in option one. They had an option to go to a second position. Do you remember that as well?
Yes, sir, I do.
All right. So with Ackard, there were significant problems getting the deal even documented, weren't there?
The particular individual was a difficult person, so he meant well, and it was just very precise in the way he wanted the numbers and the charts and the verbiage to be, because he was a real estate guy, and I'm not a real estate person, but apparently they're more precise than we are in the oil and gas business. So yes, it did take some time to do that.
Tomorrow, one of my favorite Texas phrases, was it his first rodeo?
I believe it was.
Yeah. And I'm sure he did some diligence about you and AOG. You probably did a little diligence about him.
I did some, the way he met me, I wish I could recall how. That person apparently talked me up pretty good because he really didn't ever question our technical abilities and, I mean, as far as that was concerned, we never really discussed that further.
So the full farm out, I guess it was a farm out agreement that was contemplated for the first layer, for first option, that never actually got documented?
No, I don't believe it did.
And did that lack of documentation create any problems for your relationship going forward?
The problems existed before the lack of documentation, which is why that never occurred.
So how far into the deal were you on, what month were you in when things started to come off the rails?
It was late 2015, because I remember talking to him while I was skiing. So it must have been December 2015.
Were you skiing in the high Tatras, I hope?
No, sir, I was not.
It's a lovely area. So you put in about, I should say, you loaned about 2 million from January 2013 through September 2015 into the project, correct?
I don't know if it's a loan or an investment. I didn't characterize it really anyway on purpose. It was money the company needed. It's my company. I funded it. So, but yes, I haven't looked at those numbers, so 2 million sounds about right though.
But I do want to pay attention to how the money went in. How did it go in?
My money was in whenever it was needed, which is a practice that I have with my businesses. I don't like to fund too much in advance. And at this point in time, when we did this transaction, I know that the 230 came in, and I am pretty sure that the next tranche as well came in.
You're referring now to Acker's contribution?
Correct.
Yeah.
Because that's the only other funding that came in.
I was referring actually to your funding.
Okay. Well, mine just came in as it was needed, as it
Okay.
always has been. So,
To borrow an analogy back to those real estate guys, you were the construction lender.
I don't know the real estate business well enough to say that, so.
You were.
Okay.
So take a look at 142, if you would. Do we have that up? C-142, I'm sorry, R-142. So this was and again, this is a lengthy letter. You might remember this letter. January 2 was it was your notice of default to Ackard. On the first page of that letter, you say, I loaned about 2 million. See there at the background down at the bottom. I loaned about 2 million from January 2013 to September 2015 to pay for almost all of DG's share of the geophysical work required to progress the Alpine project. Was that a true statement?
I assume so because I wrote it.
All right. And when you loaned money to the company, did you execute promissory notes? I mean, did the company?
I don't remember any of that. I don't remember. It wasn't something I would have worried about.
You were essentially loaning to your own company, so formalities weren't too important.
I would say I was investing in my own company, whether it was a loan treated that way for tax purposes or not, that's beyond my pay scale.
So as you sit here today, you don't know whether this statement that you loaned money was the case or some other structure might have been used. You just don't have any memory of it.
The loaned language, I'm not certain about that. I may have been advised to say it that way. I don't know. But in my mind, all along, it was an investment, and if I could treat it as a loan and get it back from an investor group, then wonderful, but it was what it was.
So in terms of the mechanics of how you would advance funds, did you advance it from another company or did you advance it from your own resources?
I have a number of sources I could have used.
But you don't have any memory of it.
I don't remember one way or the other, no.
But basically, people on the ground at the given project, as cash needs came along, would send you an email.
It wasn't quite that informal, no.
Okay.
Um,
Tell me how it was, please.
I'm pretty sure that in every case, Alex would have been the one that was telling me the need, and I was working out payment with him or through him.
And did you sometimes mix the sources of the funds? I mean, sometimes from your personal accounts, sometimes from another business?
Well, let's make sure we're talking about the same thing, or.
I'm talking about the 2 million that you said you loaned.
All right, but it doesn't say. What I would have done, any transaction that I would have made would have been to Discovery first. And then Discovery would have disseminated that to Alpine as needed. As long as we're saying that, please rephrase or please ask me again.
Well, is there any evidence in the record that you advanced funds to Discovery as opposed to AOG that you're aware of?
I don't think I ever advanced funds to Alpine.
Right, my question though was a little different.
Okay.
Is there any evidence in the record of the entity to whom you advanced funds?
I don't believe there is.
Now, same question for Ackard.
I don't believe there's anything in these documents. No.
Do you recall how much your total personal investment was to the Polish projects that were being developed at the same time you were working in Slovakia?
I remember around 2017 that I was at 6-point-something million in all of these projects of Discovery. But I don't remember a breakdown per project.
Okay. Did you have some good fortune in Poland? Did you generate some producing wells that you were able to move into production? On the projects that were the subject originally of the deal with?
The project with the Polish Oil and Gas Company did not go well in the end. So no, we were not successful there. Our own little project there The drop in oil and gas prices made that sub-economic, so I had to drop that. So overall, there was no return to that investment to date.
Now, you had made, as you earlier noted, and I read with interest your discussion of your experience in fracking. You'd made a substantial contribution to that work and received substantial rewards as a result. Is that fair?
Yes.
And you're probably tempted to be modest, but you're allowed to brag when somebody asks you a question that calls for immodesty. So when you say your name was put on the map in connection with fracking in the US, what do you mean by that?
I was the team leader and the geologist and the main technician or technical person for the development of fracking in horizontal wells. While I was with Lyco Energy, we started the Bakken play up in Montana, North Dakota, which ended up being a world-class field. At the same time we were doing that, the Barnett Shale play in Texas was happening, and neither of us knew what the other was doing. So we thought we were the only ones, but turns out we weren't. But that project developed for several years while I was with Lyco, and then I did that on my own for several years after that. The result was I was swamped with speaking engagements and all sorts of things. So it was a very fun time, very good part of my career.
And you met some folks there who knocked on your door later about going to Europe.
No, I got a phone call from, I believe, from London, from a guy that used to come to Dallas quite often. And he had heard of me from somewhere and invited me to go to Europe.
And you said yes.
After some struggling with the decision, yes, I did say yes.
And when was that?
2007.
And was your work in your initial work in Europe, was that conventional drilling, or was that for what we've been loosely describing as fracking?
The first that we did, that I did, was with 3 legs, and that was horizontal wells with fracks in a gas play in northern Poland.
And that was successful?
I thought it was successful. ConocoPhillips, with all their overhead, did not.
And you were invited to speak in a conference in southeastern Poland a few years into that work?
Actually, near the beginning. I believe it might even have been 2007. Yes, in Charna.
And how far is that from Slovakia?
Very close. Maybe 40 miles, 30 miles.
And did you meet some folks from Slovakia there?
I did not that I knew of.
And what did you speak on at the conference?
I spoke on the potential of the Carpathians and but mostly on the aspects of horizontal drilling and fracking in horizontal wells.
And by that point in your career, that was really your primary area of expertise. I mean, that's not to take away of anything from your other knowledge, but that's where you had been focusing for some time.
I had a long career in conventional, now it's called conventional, vertical well drilling. that was also very successful. But certainly the horizontal and fracking was an important part of my career and an important aspect of why I went to Europe.
And do you recall, both in the United States and in Europe, that there was a fair amount of controversy from environmental groups, for example, around fracking?
Yes, I do.
And you had a fair amount of exposure to environmental groups, protest activities, litigation. You'd had that rodeo too.
No, sir, I hadn't.
You had not.
No.
So had any of the projects you'd been involved with had any controversy associated with them?
Controversy is a very broad word. If you mean on the scale of demonstrations, I don't believe so, no.
You are aware that several EU member states at one time or another had fracking bans imposed.
Later, after I had done the work with in northern Poland, yes.
And what time frame was that it became a hotbed of activity in Europe?
I don't remember, but I would assume it's 2013, something like that, and onward.
Shortly before your acquisition of AOG.
It may have been.
Right. Now, you've testified, as has Mr. Fraser, that you had no plans for fracking in Slovakia, correct?
We had no plans for any what is called unconventional activities whatsoever.
And would you agree with me, sir, that there was nothing in your license agreements or any other documentation with Slovakia that would have precluded your use of those activities?
That's true.
And when you arrived in Slovakia, a lot of activist attention was focused on the question of whether that was your plan for Slovakia, correct?
Well, to be clear, there were only 3 or 4 activists that were asking any questions of us at all. And we made it clear every single time that there was not only no intention on our part, but there was no reservoir for which that technology would be applied.
Now, you've made the statement that there were 3 or 4 activists that you were dealing with. Did I hear that right?
As far as people that we were talking to, that I was talking to at town hall meetings, things like that, it was really just 2 or 3, maybe 4.
Do you remember a press conference that was held in Prešov?
I do.
And there was quite a large number of people there, wasn't there?
I'm sorry, it was a room full of press, if that's what you mean.
Are they people?
Yes, sir. I'm sorry.
Well.
I'm sorry. Yes, you're
No.
right.
That was fairly early on in your work in Slovakia, correct?
I don't recall that being early on. Certainly we had, well, it was late 2015, I believe, something like that.
Do you recall the petition activity undertaken, for example, in Smilno?
I remember hearing about it. Alex was responsible for that, so I I would hear from him, but I wasn't actively involved in that.
Mr. Lewis, you and I have the pleasure, as do all of the professionals in this room, of working and living in democratic societies.
Yes, sir.
Correct?
Yes, sir.
And you accept that in democratic societies, particularly in the EU, the state is expected to make room for, tolerate, even protect the right of protest.
That I can't comment on that. I don't know.
Well, certainly in the United States, you're familiar with protests from time to time.
I am, but I have never looked into the legality of it. So
Well, you remember hearing about the First Amendment?
of course, yes.
Yeah. The right to free speech, assembly, and the right to petition the government.
Yes, sir.
You wouldn't be surprised to know that there are comparable protections in the EU legal order, would you?
I would not be surprised.
And you accept the fact that the state cannot take any action to stop people from exercising those rights.
Again, this is not something that I can comment on. I don't feel comfortable.
I don't think there's any controversy about that right in this case, but I just wanted to make sure that you appreciated that there is a right for citizens to organize and be heard on matters of public interest. You understand that?
I would assume that's the case.
And having done business in the EU, you are, of course, familiar with the EU legal orders tolerance for public participation in the environmental impact assessment process. You're not a stranger to that, are you?
Although I bore the brunt of that activity, I am no expert in the process itself.
Do you accept, for purposes of our discussion, that the EU and Slovak legal order accept the right of citizens to be heard during that process?
Again, I can't comment. That's not something I'm an expert on at all.
Whatever may have been the legal situation, nobody's asking you whether you have an appreciation as a lawyer or a constitutional scholar or professor of international law. When you invested, did you understand that it was possible that there might be community expressions of positions around the location of your wells, around the fact that you were drilling it all for oil?
Yes, sir. Yes,
Yeah.
thank you for clarifying.
That's my question. I don't know. I'm not sure what Mr. Alexander wanted, but that's what I'm interested in. Thank you.
Well, thank you, because you said it much better than I did. That's
I
what I was trying to
I
get
don't think
to.
so, but thank you.
Before you purchased AOG, you met with the folks at San Leon,
I did.
and were they forthright in explaining to you what their perception was of the environment in the various locations where you plan projects?
In hindsight, no.
Did you discuss with them whether there were any organized environmental groups? Does the name VLK ring any bells?
That name I did not know that name at the time. I learned that later. I don't believe they disclosed anything of the sort, as I was looking into that project.
Did you inquire about anything like that?
I inquired about, their experience working with the ministry, their experience, running the seismic, and they told me they had never had a problem. So to that extent, I was comfortable.
And how long after, so well, let's be clear I just want to make sure your testimony is that before you invested, you had no understanding of organized environmental groups active in the area.
I had no knowledge of specific organized groups, if that's what you're asking.
Okay.
No, I did not.
What about the general presence of groups or people of environmental interest, environmental causes? Were you aware of that?
I'm not sure what scope we're talking about. Inside Slovakia, inside that area?
In the area of your concessions,
Please ask the question again.
before you invested,
Yes, sir.
did you have any understanding of whether there were active environmental groups in the areas of your concession who might have interest in your plans?
I don't believe I did.
And tell us, if you would, please, whether that's the kind of inquiry you would ordinarily make before investing in a new geographic area.
I thought that the questions I had asked about, had they had any problems working through the seismic, which is quite intensive on the ground, they would have had to relate with a lot of people. And the fact that that operation went smoothly, that they didn't come forward with any difficulties there, and then had gotten ready to drill a well, and hadn't run into problems there, told me that it wasn't a problem there. That's really all I knew at the time.
I don't want to interrupt again, but I'm going to ask a similar question to what I asked a moment ago. Because I'm not sure if you're answering a question regarding an awareness of specific groups and specific protests, or whether you're saying that you never contemplated the possibility that members of the community might express concerns related to environmental issues at your concession sites.
Certainly, I consider it a possibility. That with all of the noise around the oil business at that time, I wanted to make sure that when we went into this project, that we took a proactive view as to what we were doing and what our goals were, what our intentions were, so that we didn't have the kind of demonstrations that ultimately we did have. Thank you.
You're familiar generally with the events of 2016 at Smilno, are you not?
Most of them, yes.
And you talked about them in your witness statement over several pages. In most of those reports, you're reporting on information you learned from your colleagues on the ground in Slovakia. Is that fair?
Much of this, yes.
And did you, in connection with this arbitration, ask any of those colleagues if they would be available to come testify about the events that they observed on a firsthand basis?
Yes, I did.
And to whom did you speak?
Ron Crow, Maciej Karabin.
I'm just interested, not in what they would have said or what you even talked about, but did you ask Mr. Crow if he could come?
I asked him if he was available to do so if needed.
And did you ask Mr. Carabin?
The same question, yes.
And did they both say, yes, they would be willing to come if needed?
Ron said yes. Mache said probably not because he has a full-time job that would have conflicted.
Who else did you ask that question to?
Um, Personally, I think that's it. I may have asked Marek Yatskiewicz, another geologist that worked for us during that time, but I knew he couldn't because he has also a full-time job that would have prevented him to. I think that's it.
Did you explore with them whether they could get leave for a couple of days to travel or appear by video? Did you explore any of those options with them?
No, sir, I did not.
Did you, do you know whether any of your other colleagues asked if, for example, did Mr. Fraser ask if someone could come and testify?
I know that he called Stanislav Benata, who was unwilling to come. I don't recall if there was anyone else.
Did he tell you whether he'd explored with Mr. Benata the possibility of travel for a couple of days, reimbursement for costs, or appearing by video?
Yes, he did.
And what did Mr. Benata say?
He had no interest.
May I ask a question, counsel? Did you put those questions to Mr. Lewis himself, excuse me, to Mr. Fraser himself? That specific question?
With respect to Benata, yes.
Right. I'm not sure I recall these specifics.
Yes.
I recall. The record is what it is. I just want to be clear. I just wondered whether you're asking about details of a
Oh, I
conversation.
did not, you're correct. I did not ask about those details.
Right. So I suggest that he would have been the better witness to get that evidence from about his conversation with Mr. Benata. But anyways, that is what it is.
So in 2016, over the course of that year, and having spent a lot of time with Mr. Fraser on it, I don't intend to replow the ground, but you were aware generally that there were protests
Yes.
at Smilno. You were aware there was litigation going on,
Yes.
and you were aware that there were interactions with the police where people were making complaints to the police about your activities and vice versa.
Yes.
And at the end of 2016, you had suffered a number of adverse rulings in litigation. Is that true?
A number of them. I'm aware from litigation. I think there's only one that I'm aware of.
You have before you a demonstrative exhibit that shows a timeline. Do you see that there, sir?
Yes, sir.
Were you aware that an injunction had been obtained by Mrs. Varianova and had been affirmed by the Court of Appeals? Were you aware of that?
I was aware of the injunction, yes.
Were you aware that it was in place from February of 2016 through the end of the year and beyond?
At the time, I really let Alex handle that. I wasn't keeping track of that, so I knew that it had happened, but I did not know whether it was still active or not.
If you had known that AOG was entering the access road in breach of an injunction, as CEO, would you have put a stop to that?
I can't just answer that yes or no. I would have to know the facts behind the situation. And on the surface of it, it sounds pretty cut and dry, but I would have to understand what was behind it all.
Well, what's the cut and dried answer to the question whether you would have approved of violations of an injunction?
Provided there are no extenuating circumstances, I would obviously want to obey the law.
And were you aware that AOG had asserted that the road in question was a public special purpose road, and that statutory basis was an attempt to justify its use of the road? Were you aware of any of that?
I know I was told that it was a public road and that we were able to use it, and that was what our council told me. So that's what I relied upon.
Were you told that up until December of 2016, AOG and its subsidiaries had never taken any legal action affirmatively to stop protester blockings of the access road?
No.
Were you aware that litigation was filed in December and January of 2017 on behalf of both AOG and a subsidiary called Sesti Smilno, but that the applications for injunction were refused in both cases? Were you aware of that?
Not specifically. I knew that Chesty Smilno existed, that Alex was investigating that as an option to being able to use the road that the protesters were blocking. But again, I did not get into the details of that.
So in that same period of time, if we look at C41, which I think you still have before you, it's the graph of the, this is your exhibit. Do you see that there? So if we look at 2016, the period of 2016, that appears until the pandemic, it looks like it's the first quarter of 2016 is as low as it got. Does that ring a bell?
That looks correct.
And then there was some improvement through the balance of that year. Do you see that?
I see that the oil price stabilized around $50, which was the most important aspect of it. Yes.
Now, was the price level in 2016 impacting at all your ability to attract external investors?
I'm sure.
And do you think if prospective investors had conducted an appropriate due diligence process and learned that you had been enjoined from accessing drilling sites and had unsuccessfully litigated your theories of access, to the drilling site, do you think that would have an impact on investors?
That's a lot of speculation.
No, it's actually not, Mr. Lewis. The fact that those injunctions were in place and that you did not have success in establishing any legal entitlement to the access road, that's not in, that evidence is before this tribunal. So let's assume that's the case. Do you think if investors had asked you or Mr. Fraser, how are things going with that protest group I hear you've been working with? Do you think that the news of those injunctions would have impacted potential investors?
I think that any investor is going to trust that the operator is doing whatever is necessary to remedy the situation, and would have assumed that was the case, as I did with Alex. Things like that happen, you deal with them, you fix them, and you move on. And most investors that would be interested in a project like this would understand that those things happen.
And they'd be more interested in the technical merit of the project.
I'm not sure what you're asking me. I'm sorry.
Well, it's not a sophisticated question because I'm not an oil guy, but I assume investors know something about the business, and what they're really interested in is the technical merit of the prospect of a picture for the project.
Well, most investors are actually interested in the financial merit rather than the technical. The technical needs to be right so that they can rely on the financial.
Right. Okay. And that's the sense in which the low oil price can have impact on their perception of the financial merit.
Yes, true.
Yeah. Okay.
Wouldn't they be interested in a very unsophisticated question, whether or not you can actually get access to the location where you say there's a lot of oil at a good price?
Certainly, certainly. And as I had every expectation that the problem would be resolved when Alex first told me about it. So
Remind me again when, I want you to call him Alex, but when Mr. Fraser.
sorry.
No, don't. You may call him Alex. When Mr. Fraser first told you about the problem of access to the site?
Do I recall when?
Yes.
I'm sure that it was right about the time that it happened. So I would assume February of 16.
Right. And you were aware that it went to more than one instance of the local courts, more than one level of the Slovak courts. You don't recall knowing
No,
that?
sir, I don't think I was involved in that.
Okay. And when you say that, look, this is not your first rodeo, right?
Right.
In the oil and gas business. It's not mine either, but I have a completely different approach. I'm like the guy who watches the guys ride the bull, right? You're riding the bull.
Yes, sir.
I understand that investors, by their nature, hope and expect that the operator will overcome problems. But surely there are certain problems which an investor can understand may be insurmountable. There might be laws or regulations in place that are insurmountable and can't simply be overcome even by the most savvy operator. Is that?
That's absolutely correct.
Okay.
Thank you.
And what's your sense about whether the investors you were speaking to may have thought, had they been told that two levels of courts had said, you cannot access the Smilno site unless the people living there allow you?
Again, I would have wanted to know some more background to the issue because I did not. I would certainly have told them it existed, but at the same time, I would have had an expectation of a solution before I told them. So since I didn't know, I therefore didn't have the solution either. I
Fair
hope that
enough.
answers your question.
Thank you. Thank you.
Mr. Lewis, do you remember towards the end of the fourth quarter of 2016 and going into 2017, having a discussion about the possibility of talking to the key activists to see if you could find any common ground with them?
I remember that, that's what Alex suggested. At that point in time, I was getting pretty fed up. But he believed he could, make some headway by doing that.
And if you turn now to paragraph 83 on page 29 of your witness statement.
Yes, sir.
Third line down towards the middle of the page. I agreed with Alex Fraser that it seemed that we had little choice. Let me just stop there for a second.
I'm sorry, I gotta stop you.
Oh, sure.
Which paragraph, please?
You see the page 29,
Yes, sir.
3 lines down. I agreed with Alex Fraser
Yes, sir.
that it seemed that we had little choice but to talk to the key activists to see if we could find any common ground with them. You see that?
Yes, sir.
And you confirm that, you agreed with that.
Yes, sir.
So the phrase, it seemed we had little choice, sort of intrigued me. It sounded like you were reluctant. Were you reluctant?
I was, to the point of wondering whether it was time to exit the program, because of all the hurdles that had come up. And this seemed the last possibility. It's not something that I thought would work. I didn't trust the activists at all. They had disrupted our meetings on numerous occasions. There was no interest seen in them of what the truth was, or all they wanted was to stir up the public. So I didn't see how this would lead anywhere different than that. But nevertheless, because Alex felt that way, I wanted to support him in that effort.
And you were soon pleasantly surprised by the results of the first meeting, were you not?
I would say no to that question, because the introduction of the requirement for an EIA was something that I did not ever think we could get through.
So you were concerned about the introduction of the requirement for an EIA.
I was very concerned, yes.
All right. So let's look, if you would, please, at exhibit R117. I understand this to be an email from Mr. Fraser dated the 5th of February, 2017, with a long list of addressees. I wonder if we could trouble you just briefly to ask you to identify the roles of each of these people.
Dasha was our PR person out of, I believe, Bratislava. Andrea Book. I don't think I know Andrea. Katarina had attended a meeting with the minister with us, so I think she was a lawyer. Victor certainly was. Vladimir, I feel like I should know Vladimir, but it's not coming to me. And then Mate Sakura had also been an attorney for us, a lawyer for us.
And the CCs were to Mr. Banata. He was in a management role in Slovakia on the ground, right?
He helped us a great deal, yes.
What was his actual title? Do you remember?
He was a consultant. I don't know that he ever had a title per se.
All right.
Could
you go on? We're
Oh.
almost through there.
Emelis is an engineer who did work for us. Peter Stinek. I'm sorry, it's been too long. I don't remember Peter. Mache, of course, I remember. He worked for us as a geologist and engineer.
So now the subject is meeting with FERCO. Do you know who FERCO is?
Yes, I do.
Who was he?
A local.
Was he an activist?
I try not to characterize him as that, but I suppose he probably was.
Can I just, what do you mean by an activist?
I'm sorry. Yeah, that was
I mean,
vague.
it has a very,
I like the guy a lot.
it has a rather pejorative tone.
I'm sorry. Yeah, I like the guy a
And
lot.
I'm just wondering why you keep using that phrase,
Which phrase? I'm sorry.
activist.
Oh, I didn't realize I was. Because the activists to me had been so unreasonable. When people got unreasonable, I guess that's the term that I used. People that
So it does have a pejorative element.
it does for me, yes, sir.
And
Because
what are the characteristics of an activist? What makes someone unreasonable?
Don't say he has a beard.
Or that he cares about the environment?
it is, I mean, anybody that cares about the environment is, I mean, I love talking about the environment because we do so much to protect it and I'm so interested in it myself. It's the people that really don't care what your answer is. They're just there to make noise and get angry and stir people up that are the problem for me. And that's what I term those as activists.
So there's a sense that they don't have a genuine commitment to the cause they espouse, or in the case of Mrs. Varyanova, who seems to have been a particularly bee in the bonnet for your side of things. What's the problem with her? She lives there.
I'm sorry?
She lives there.
Yes, and on numerous occasions, I tried to discuss the project with her, and all she would ever say to me was, "Go home." There was no discussing with her. So, I mean, I respect that she didn't want me there, but to stir people up on the basis that we were somehow polluting the water, no, that was just a means to her end, in my opinion.
And so was her expression of you illegitimate?
I think she mischaracterized our operations on several occasions, yes.
Thank you.
Let me follow up on that if I may. By doing it now, I won't come back to it later. An expression I suggest most people in the room understand is NIMBY, not in my backyard. It's an
Yes.
expression that I haven't read anywhere in any of the pleadings. But when you say that Ms. Varyanova, by way of example, may have been using environmental concerns as a pretext, or to put it in Professor Sand's words, may not have actually felt an adherence to the views that she's expounding. Are you and she told you just to go home. Are you saying they just didn't want it next to their village? I mean, what motivation do you ascribe to her?
She owned a ski resort 2 kilometers away, something rather close. And she had a ski resort with a spa pool there, and some lodging. So of course, her tourist trade, I'm sure she felt that it would be impacted by our operations. At least that's the way I explained it to myself. Because that's the only thing that makes sense to me. But the other aspect of that is, the publicity that would come from her, activities couldn't hurt the ski resort either. So, but those are purely my opinions.
Well, I'm only asking your opinion, of course. And what about the activists who came from other villages?
I'm sorry, what's the question?
Well, excuse me, what motivated activists? What about the people that you would consider activists that didn't live right next to the Smilnos site? What's your opinion about their motivations for doing so?
Again, when I tried to address their concern, their supposed concerns, they talked over my answers. They weren't the least bit interested in the facts. In our town meetings, when we would talk about the chemistry and the drilling mud, we'd get 3 words out and they would talk over us. I mean, they just never had given us any inkling that they were really there to address environmental concerns. There was something political going on, in my opinion. That's the only way I can explain it.
Very good. Thank you.
Yes, sir.
Just to be clear about that, why isn't the question of environmental amenity and landscape an environmental concern? I mean, if you ran a ski resort, would you feel relaxed about someone putting an oil rig right outside your ski resort?
No, and I can sympathize with her. Absolutely can. I know that the impact of what we were doing would not have affected much of the scenery, but it would have to some extent, of course. So yes, I can understand her position. What I take issue with is the means that she used to address that. It was just not truthful.
Parking her car.
Well, that too, yes.
But don't you have a sort of grudging admiration for her? Is that actually here is someone who is a local resident, who we were told owned part of the land, had a business. She was defending her interests. What's wrong with that?
Again, if she had done that honestly, I would have no problem with that. And I address that in many other places as well. It's a common thing. And it's an unfortunate thing that oil field machinery is unsightly, no matter how you dress it up. But had she gone about it, look, that's all it was, I'd been fine. I'm sorry, we'll do what we can to help you. And we probably would have. I do a lot of things in communities when I drill and complete wells. I want people to be happy and us to be part of that community. But she never gave us a chance to go there. So
Because she just didn't want you there.
she just did not want us there. Yes, sir.
Mr. Lewis, my colleagues have reminded me I'm taking too much time. So I'm going to try to speed up.
It's not entirely your fault. sir.
Well, no, but I'm going to try to speed up so we might be able to finish with you this evening. So with that goal in mind, I appreciate your succinct answer to a few questions here. Take a look again at R117. You've seen this before. It was, you were copied on it and some of the follow-on correspondence. Did you have a chance to look at it in preparing for your testimony here today?
I have seen this, yes.
And the first thing Mr. Fraser writes, this meeting seems to have been surprisingly productive. And his sentence after indicating who was there. Well, first of all, did you learn why he was surprised that Lukacs, Sabo, and Barthas from VLK showed up? What did you understand why he was surprised?
I think he had arranged the meeting with Furco and Andrejko, and the fact that they showed up was the surprise.
And you knew by this point that VLK was an environmental activist group.
Oh, yes, sir.
And did you share his view that it was a positive sign that they had showed up and wanted to talk about their concerns?
No, sir, I did not.
You did not think that was positive?
No, because their actions at too many locations had been disruptive and problematic.
All right. And I think, I don't mean to diminish any of this email. I think it's all important, but in the interest of time, I am going to move on quickly to the comment about Mr. Lukács, who said he considered the issue was not so much about environmental impact, but more about local politics, and accepted. And having had previously doubts about whether to attend the meeting, having heard the discussion, he was glad he did. Did that give you any hope that there might be something positive come out of this?
I don't believe so. The man had been so disingenuous so many times, I really did not trust it.
And as you read on further, Mr. Fraser identified that the most important element in promoting trust would be to comply voluntarily with the preliminary environmental procedure for all wells. And he said that was doable. You see that?
Yes,
I've gathered from your prior answers that that did not probably thrill you either.
it did not.
Did you let Mr. Fraser know that you did not approve of that?
Yes, I did. Now, excuse me, it wasn't that I didn't approve, I just did not like it.
All right. Were you willing to support it?
To an extent, yes.
But only to an extent.
Yes, sir.
So again, rushing through this big picture, you no doubt learned that further meetings were held,
Yes, sir.
including with Mrs. Veranova.
Was not aware of that.
Did you ever tell Mr. Fraser to stop these meetings? They weren't going anywhere.
Not at this time, no.
Did you understand that Mr. Fraser at one point proposed the possibility of getting together, trying to find common ground, listen to their concerns, and document all of that in a joint press release? Did you become aware of that?
I did, and Alex also expressed concern about their true intent, but told me that he was willing to take the risk to go along with it because it really was our last opportunity.
And in fact, at that point, you were low on funding, correct?
Well, the company was being funded as needed, and I was funding as little as I needed to. It isn't that the money wasn't there, it's just I didn't want to spend any more than we had to.
And I'll represent to you that the evidence in the case is that you were still the subject of an injunction at Smilno. And in the latter part of these meetings that you had unsuccessfully applied for an injunction in your own interests. I'll represent that to you. In view of that, you really didn't have any choice but to meet with them. Wouldn't that be fair to say?
That's the way Alex viewed it, and the way he explained it to me, that made sense, yes.
And if you would look, please, at C-166.
And if I may, certainly that wasn't the only option available to us, but it seemed by far the best one at the time.
Now, C-166 is before you, and I'd like you to look at the first paragraph in particular. And within that first paragraph, I'm particularly interested in discussing with you 6 lines down the sentence that begins "on the basis that." And I'll represent to you that this was a draft of the press release dated February 2017. C-166.
Yes, sir.
Do you see that language?
Yes, sir.
And now if you would turn to 171, C-171. You'll see that the language I highlighted, or rather that our assistant highlighted, is not in that version, 171. The language to the effect that VLK and the local community will accept the outcome without filing an objection or appeal. You see that?
I remember Alex commenting about this and saying that takes the teeth out of it, that makes them totally unaccountable. But again, he said, I don't see that we have any choice. So he suggested we go with it, and I said, okay.
So would you agree, sir, that rather than view it as taking the teeth out of it, the activists were making clear to you that they were going to have the right to participate in the environmental impact assessment process, because after all, that was their number one priority going into the discussions?
We had given them numerous opportunities to participate, and in every case, they caused disruption, delay, for no reason. I was under no pretext that this was going to be any different. And Alex felt a little more optimistic than I did, but I felt that it was very doubtful that they would be willing to go along with whatever we presented without making it a political tool instead of allowing us to continue.
It is true, isn't it, Mr. Lewis, that since the date of this agreement, there's never been another protest at any of the 3 sites that were involved in the activists, with the activists that you were meeting with?
I don't know the answer to that.
It's also true that there's never been another road blockage at any of the sites. Were you aware of that?
I don't know that we've tried to do anything that they would have blocked us. So it's, I guess the answer would be yes on that basis.
You authorized Alex to release this press release, correct?
I did.
And you're not aware of any document where the activists or anybody in the community or any governmental agency forfeited or otherwise waived their right to participate in the environmental impact assessment? You're not aware of any such thing, are you?
No, I'm not.
And Alex never told you that that was the deal, that they weren't going to have anything to say in the environmental impact assessment process?
No, he made it very clear that they had promised to not disrupt our operations going forward. But then soon thereafter started disrupting our negotiations, and therefore we came to the place it was just not worth going forward anymore.
Well, let's try to be a little clearer about what was the subject of the agreement. I'll represent to you that there's nothing in this document that could be construed as a forfeiture of their right to participate in the assessment process, because it was a guaranteed right under the law. But they did, as I understand it, commit not to disrupt work sites, blocks, block things, that sort of thing. Does that refresh your recollection at all about what the agreement was?
Certainly implied in the agreement was that they would be working with us on the EIA to make sure that they understood and did not see any problems with our operations. But in fact, we got more of the same when we started submitting documents. They objected and disrupted and caused all sorts of difficulties that were non-rational, which was not the spirit of the agreement.
So would you agree that none of the other governmental agencies or institutional commenters on the environmental review process had ever made any commitment that they could not participate in the assessment process?
I'm aware of none.
I'm going to ask you to take a look at C 382. And if we could go to the third page, this is just, I probably moved too quickly, but these are minutes of the operating committee of 3 October 2017. You're the secretary of the meeting. And they're signed by all three JV partners. I want to call your attention to the third paragraph on page 3. And under the Slovak law. And in particular, the sentence that reads, Alex said that he feels that it could be a long process, but that he felt we will ultimately prevail. You see that?
No, sir, I don't. I'm sorry.
Okay, it's page 3, paragraph 3 at the bottom of the page.
Oh, I'm sorry. Yes, I see.
Yeah, I didn't say that very clearly.
Okay.
All right, and then JKX said, and then this next sentence, Alex said that he feels that it could be a long process, but that he felt we will ultimately prevail. Did you understand him to be talking about the environmental impact assessment process?
Sitting here today, I cannot tell you one way or the other.
There was a tone of some optimism in the comment. Would you agree with that?
I would agree with that.
And then turn, if you would, to Mike Lewis, Alpine, stated that AOG doesn't have the funding in place to continue to battle or for arbitration, suggesting that Alpine doesn't have the horsepower or appetite for it. Do you agree that's what you communicated to the JV partners at that meeting?
Yes, it is.
And you proposed to reduce your interest to 5% and stay involved. You can scroll the page for him, please. And then the final note was, but Alpine didn't feel that it would be able to pay its share of the license fee. Is that an accurate report of your views expressed at that meeting?
It is.
Right. You had concluded at that point that you were going to wrap it up, hadn't you, sir?
I was fed up. Yes, sir.
All right. That concludes my examination.
Thank you. We have been going for a long stretch, and I apologize to the court reporter because it's this, in addition, getting late in the day. So I suggest we take a short break now and then wrap up this examination. Is that fine?
Sure.
Mr. Jean?
Of course, Madam President, I can tell you now I don't have any re-examination if that assists you as well. In terms of
But
timing.
fine,
Yes.
that is good. So, but it's not yet the last word in the sense that we're not necessarily all going home right now. So because the tribunal may have a few
Yes, of
questions. So, Mr. Lewis, while you're on the witness stand, you cannot communicate with anyone, but you can have a coffee or whatever you wish, of course. Let's take 15 minutes and resume at 15 past. I see everybody is ready for the last stretch of the day. You confirm that you have no redirect question.
I have no redirect.
Good. Fine. So do my colleagues have questions for Mr. Lewis? No. Do you,
I have a couple if I may.
sure, of course.
Can I ask you to turn your mic off for 1 second? I want to start with a question to you. Thanks. Hello again, Mr. Lewis.
Yes, sir.
I've got a couple of questions for you. Some are particularly related to statements that you made in writing, and some are related to your statements made orally today.
Yes, sir.
Let me begin by following up on a question that Mr. Alexander put to you in respect of Mr. Crow. I want to be sure I've understood correctly. And please don't hesitate to correct me. I'm not here to put words in your mouth. I want to be sure that I've understood your testimony. I don't have a transcript reference, but I noted down that you said that Mr. Crow told you that he would be available to testify if needed. Is that
Yes.
correct?
Yes, he did.
At any point in time, did you or your lawyers on your behalf tell Mr. Crow that his testimony would be helpful in respect of matters of which he and neither you nor Mr. Fraser had firsthand evidence?
I left that up to counsel, that decision. After asking him one time and relaying that to counsel, I don't think I've asked it again.
Excuse me, counsel, object if an objection is to my question, if an objection is appropriate. I don't understand what you relayed to your counsel. You said you related to them once and then you left it. What did you relate to them?
I related that Ron had said that he would be available if needed.
Very good. Thank you. You said something very early in your testimony today, which I found, I found a lot of your testimony very interesting and all of it very helpful. But this is something I hadn't quite considered nor taken from your written evidence. You alluded to the fact that this was a difficult funding effort these are my words now, by virtue of the fact that this was at the early stage and it was a funding of a project rather than a particular well.
Yes, sir.
My apologies to all if I missed this distinction in the written materials. Could you elaborate shortly on why this was difficult and what you mean as to this being a particular funding effort rather than a typical funding effort?
When I typically go to sources for funding, I'm prepared with prospects, places to drill, expectations of cash flow, and all those things. And I just was not prepared at the time that Gulf Shores, for instance, was brought on board, or even the initial period there where Claremont was looking for people for us. So I mean, I had a general idea, I could wave my arms, but I didn't have anything that specifically I could point to that I would typically have in a package for an investor. So that made it difficult for Claremont, made it difficult for us to relay what I expected the potential to be and the cash flow to look like.
Okay. I wonder whether this might actually relate to my next question. Whether it does or doesn't is irrelevant because I'm going to ask the question anyways. You said at some point that this I can't point to a transcript reference. It's at 1551 if counsel wants to look at it. You said my dollars my money was wherever it was needed, something
Yes, sir.
like that.
Yes, sir.
I don't like to fund too much in advance.
Yes, sir.
You recall that?
Yes, sir.
Now, let me put to you two propositions which I understand are suggested by the Republic in these proceedings. That first of all, your Slovak operations were effectively living hand to mouth and were effectively eventually starved of cash. And the second one is that your unwillingness to fund in advance resulted in a lack or an insufficient technical and legal due diligence. All right. My understanding is these are elements of the case brought or the defense. Have you got any comment about that and how that might relate to your willingness or unwillingness to fund too much in advance?
Yes, sir. Thank
ahead.
you for bringing that up. At no time did I starve the company for cash. We always paid our bills. We always knew that salaries, et cetera, would be paid. This company has always paid its bills. But I'm not going to pile up $1 million in the bank just so that everybody can look at it. I mean, there was always the money available to do what we were doing, and never a specter of running out in that regard. What I talked to Ramgas in that last exhibit about, what I relayed to Ackard in communication there, was that without your funding, the vacancy that your funding provides means I have to kick in. Alpine itself is going to run out of money. I'm going to have to fund is the inference. I didn't follow in with that each time, which is why I think it's been interpreted that way. But I never had any intention of leaving the company without funds to pay its bills and do what I had approved to do.
And what about the issue of insufficient due diligence? That's my understanding of one aspect of the defense's case. Have you got anything to say about that and how it may or may not relate to an unwillingness to fund too much in advance?
May I ask, are you talking at the beginning of the
Yes,
project?
at the time you invested.
Yes, sir.
Excuse me, I should have been precise, and thank you for clarifying that.
Yes, sir. The work that we had done in southern Poland prepared me for what the expectations were in Slovakia. It was a no-brainer to me that stepping across the line was going to be the same kind of geology and expectations of not the same, but very close to the performance that we had seen there. And the expectations I had there, had I been allowed to drill there. I didn't describe, and please stop me if I get too long-winded here, I tend to do that. But the Polish Oil and Gas Company had lifted their skirts, as it were, for us to go into their data room and evaluate all of their fields. So we had access to data that theoretically no one in the world other than us had. And that gave us an insight as to how to predict these reservoirs and what to expect at this project. So again, it was a very easy thing for me to get into and feel very comfortable doing.
And what about the concept of legal due diligence? Right. Was that related in any way to funding, cash?
No, sir.
No.
No, sir. No, sir. I asked the questions that I thought I should ask, that I felt I needed to ask with regard to this project, and San Leon indicated they did not have any legal problems that would be an obstruction to us. In fact, had proceeded and been successful in their seismic and initial operations toward drilling. So I had no indication, and I thought I'd asked the right questions. I had no indication from them that there was a problem.
Very good, thank you. Two more questions, and these relate more specifically to, statements in your first witness statement. Sir, could I ask you please to put that on, or you've got that in front of you, I believe.
Yes, sir.
Could you take a look at paragraph 89 of your first witness statement?
Yes, sir.
And here you say JKX informed us of its intention to withdraw from the project.
Yes, sir.
And you refer to exhibit C 185. There, I'd like that put on the screen for the witness's benefit, please.
Looks like the computer's having a problem.
Oop. There we go.
There we go.
No problem that can't be overcome, right? By a savvy operator such as our technician here.
Could you hit the no button, please, so I can read underneath it? There we go.
Now let me look for it. Maybe no, there it is.
There's a, excuse me, there's a window.
Oh, can you not see? I'm sorry. What about on the small
There we
screen
go.
there?
Yes, sir. Go ahead.
Okay. So this is, you see at the bottom there, it's an email from Mr. Wayland at JKX to Mr. Fraser, Mr. Crow. Mr. Fraser and Mr. Crow. I don't think you're, Mike at Discovery.
Yes, sir.
I guess that's you.
That's me.
And here's where JKS is telling you we're going to withdraw. At the bottom, second to last paragraph, it reads, for your information, JKX Hungary's assets are also up for sale. So this is a question I asked your friend and colleague earlier. You don't know this because you weren't here. But I put the same proposition to you. I read this, it arguably looks like JKX is exiting a number of jurisdictions, not only Slovakia. And therefore, maybe they had reasons that had nothing to do with Slovakia for selling its various Central European interests. Do you have anything to say about that? Do you know whether they had their own reasons to divest?
Yes, Richie, I know Richie, the gentleman that wrote this, Mr. Whalen. I know him quite well. We went out to dinner just after this email came in, and he expounded on the difficulties that they were having. They were in financial trouble that had nothing to do with Slovakia. He wanted me to come look at several of their assets to see if I was interested, and indeed I did look at several of them. They were offloading most everything at that point. So,
Okay, that's how, well, I don't know about everything, but I read it this way too. They had financial problems unique to them that had nothing to do with the activists in Slovakia.
no, sir.
Okay. Is my understanding correct?
That's correct. Yes, sir.
Thank you. At least that was your understanding.
Yes, sir.
Thank you. Pardon me, I think. Yes, paragraph 93 of your witness statement, your first witness statement.
Yes, sir.
And this, Madame, is my last question. The first sentence is very straightforward. The introduction of the new preliminary EIA requirement into our license was the final straw. Trying to understand final straw. Is this the point in time, or is it not the point in time when Discovery first came to the conclusion that due to the conduct of the Slovak Republic, you would cease your activities in Slovakia?
I was certainly teetering on that already, but
And that's
this,
what I'm trying to explore.
yes, sir. This act here by the government was a complete violation of law, in our opinion. According to Alex, I should say, because they changed our license, changed the terms of our license. And again, I'm relying on Alex's interpretation, but according to him, it was a violation of what they were allowed to do.
Until that point, you were still committed to continuing to invest in Slovakia?
And I did, yes, sir. Yeah.
Thank you
Thank
very
you.
much.
No questions. I was somewhat surprised when I was looking at some of the documents like the Opcom committee the upcoming meetings about the complaints about the MT survey that were not fully interpreted. Some complaints as well about the seismic data. And then I was surprised that at the same time, you are planning on drilling two wells in a very short time at the end of 2014, and then two again in Q1 of 2015. And I wasn't really, and I don't see really a drilling plan. So what was your way of operating in these in these sites?
Firstly, with the seismic and the MT, I don't remember any complaints. There's always room for seismic to be better. I mean, that's, everyone complains that we wish it was better. But the MT work, that was a technology that I included at the permission of the operating committee that I am very familiar with. It has done me a lot of good. That was a way to go quickly to an interpretation and get justification for drilling a location. And now I forgot your last question. I'm sorry.
No, and it's not a mainstream tool. You acknowledge at some point the MT data.
Yes, ma'am. It's a technology that only a very few people know about. I have used it extensively and I know where it works, where it doesn't work. I use it on all my projects. I've got a project in South Texas right now that it is the fundamental tool because it works so well in that shale sand environment like
And
this.
it works whatever the depths.
Down to about 15,000 feet, which is fine for this project and the other one. Yes, ma'am. And I did not answer your last question because I
No,
can't
the
remember.
last question was that, for instance, in September 2014, you say by the end of the year, we will have to drill 2 wells. And then a little later, you say, I mean, when you do the February 2015 meeting, you have prepared a budget for 2015, and one sees that you have 2 wells in Q1 2015, all of which didn't really materialize. So I was not sure how the operation worked, how it was planned.
Yes, ma'am. We had first of all, it took longer for the partners to get their AFEs signed than we had hoped, which that was 2 or 3 months difference. As far as getting the wells drilled, though, it was this process of finding the right location. And as we dealt with the issues of getting right-of-ways and permissions and things like that, that took longer than I expected, and our engineer as well. So it did slow the process down, but I'm trying to remember when the
Well, we can go to the documents, but I don't think that is the purpose now. I'd just like to understand in general how you're running your operations.
Well, I typically, thank you. Now I understand. In all the projects, at least in the last many years, I try to get into a place where I can drill a well as quickly as possible because where a major company might go about studying the entire project and decide, on various aspects where the best possible place is, I think that's a waste of time. If I can find a place that is quality and will provide both some cash flow, but more importantly, the proof of concepts, then that's what I seek to do. It makes everything profoundly easier. So when I was pushing to drill as many wells as possible, that was the point. Let's get some wells drilled, let's get happy and move on.
I was asking myself why you kept on trying accessing the Smilno location when obviously there were difficulties. We're not speaking of the reasons for the difficulties, but just the fact. And at the same time, you had a good relationship with the state forestry, as we read. A lot of land was in your contract areas, was state land. And could you not have found another location, especially considering your method of drilling as many quick wells?
It takes some time to get to the point where partners and we are all agreeing that this is the place to drill. But it also takes time to get the governmental processes so we can get the mining documents done, et cetera. Contracting a rig, contracting the other services, getting them in the right place. The reason I kept going on Smilno is because we built the location. We had already spent the initial, I don't remember how much, but let's say 50,000 euro, 1,000 euros, something like that, to build the location. So I hate to leave a location and, have to reclaim it. That's a larger waste of money than I would like to.
Depends how much time you save and how much production you can get out of the well in the end, right?
Yes, and that was our first gas well. The others were oil.
Yes, that was a question too, because at some time in your witness statement, you say that you will prioritize gas, and then you insist for months and months on Smilno, which is precisely an oil well.
No, ma'am. Smilno was a
No,
gas well.
no, you would prioritize oil, and Smilno was a gas well.
The advantage of oil wells is you don't need the gas pipeline
Yes.
infrastructure. So the quickest way to get cash flow is to go to an oil well. But the big elephant for this project is the gas, because at that time anyway, the gas price was nothing but looking fantastic. So I really truly thought that the gas well was the ticket and pushed in that regard.
But there was no pipeline close by, so
There is. I'm sorry.
you would have have to build the pipeline to join another pipeline.
Yes, ma'am, but the pipeline that we could connect to was between 9 and 15 kilometers away, not so far. And that was doable in my view. Once we had a test, it would have made a lot of difference in that regard.
You're a very successful businessman, and we've read about this, and it was mentioned today as well. And this was obviously not a success. And what was the reason? Was it because of the activists? Because how do you explain it? If we take now a big picture view.
I'm not preaching my case when I say that it was ultimately the governmental blockage that caused me to change my mind. When that EIA came down, everything that Alex and I have talked about, and others, Richie Whalen, others, that there are so many ways for people like the activists to insert political agendas into the EIA process. We felt that it just was never going to come to an end.
So you considered that it was the EIA that was really the nail in the coffin?
That was the nail in the coffin,
Right.
yes, ma'am.
Mm-hmm. And that was the preliminary EIA that you offered, or was it the full EIA?
Well, every indication was, and I don't remember if this is an official correspondence, but every indication was that once we did the preliminary, the full EIA was going to be required, which takes at least 2 years. And
Well, it depends on the outcome of the preliminary EIA.
if I'm
Well,
I
We can
think
check
we
that.
got to the end of one of those. I'm tired. I don't remember, but I think we got to the end of one of those and we're told that we had to go to the formal EIA. I may be mistaken, but I know that I felt that that's where we would end up.
mhm. And so what's the effect on all this of Mrs. Vajanova's car blocking the road? Is this part of the issue or?
Well, because the police didn't do anything about it, we certainly weren't gonna, exacerbate the problem by doing something crazy. We were trying to live under the law. And there just wasn't any way around that without governmental help. So it was very frustrating. It was a very simple thing for the police to enforce what I understood to be the law, that she was blocking a public road. And she had no real reason to do that other than to block us. It was pretty cut and dry for me. I hope that made sense.
You said before that you thought the engagement was what you call activists could not be productive because they were not really listening. Would more engagement with the local population have helped, or do you feel it would not be fruitful, or you have done as much as you could?
We did a lot, despite the allegations otherwise. We did a lot of community effort. In Smilno, I personally was involved in several social events. I was in the restaurant visiting with people as much as I could. And I honestly, there were only very, very few that objected to our operations. There were Ms. Varianova for the reasons we've said. But the rest, the 2 or 3 other real active activists, were not even from Smilno. There was no way to fight that. And there's never an end to how much you can do. You have to at some point say, okay, we've done enough, let's go.
Fine. No further questions from anyone. Mr. Lewis, thank you very much for your help.
Thank you.
That brings us to, you can,
Okay.
whatever. But you don't have to sit there while we close for the day. Tomorrow, we have quite a large number of witnesses. I assume this is because the examinations will be relatively condensed. Is that the plan? Yes, good. It would be good if we can get through them tomorrow.
We will try our best.
Yeah.
I think obviously we had originally anticipated, no, exactly. We're going to try our best to finish by the end of tomorrow.
Good. Excellent. Anything to be raised before we close for the day? No?
Nothing from our side.
No. Good. Then have a good evening, everyone.
You all.